dancing in jails, there are plays in jails, even recently the launch of music album from jail, and also there is cricket, very good cricket stadium, lot of cricket happening there. So it is all not that depressing. In fact, I wonder when I was in jail, had this all facilities have been provided to a normal individual, nobody will come. So it's I would say it's a question always in my mind. He had this all recreational, so organized, so planned activities, from spiritual to physical to dancing to albums, given chance to everybody, paintings. You go to Bihar Art, wonderful paintings, amazing paintings. In fact, we have a painter who's killed some reason murder case, wonderful paintings. So this all has been done in jail. So they had this been quite a opportunity outside, there is no need of jail. That's one point I would like for us to share. And doctors are not, there are 100 doctors. There are a team of about 150 doctors. There is a full-fledged hospital inside the PRK number 3. And there is a 120 bedded drug addiction ward, 20 bedded psychiatric ward, and another 100 bedded surgery ward, optional ward, medicine ward. So it's all must of a very good acute center in the jail. So as such, by medical wise, I would say it's a wonderful jail, PR jail, to get any sort of treatment. In fact, I share with you people who crying just to get a medical treatment, because sometimes the treatment is so costly outside, but through jail, we happen to see the one example. Thank you. The stigma is always there, I would say, for mental illnesses.
Dr. Sandeep, I just want to flag something that maybe your presentation was also very extraordinary, and you spoke of the huge numbers of the mentally ill in prisons. One, you linked it with the treatment of mentally ill outside prison. You spoke of the closure of psychiatric hospitals and so on. So this is again a huge issue that we may possibly think of taking up in terms of a public interest petition. The treatment of the mentally ill in India, also the treatment in jail, but it's a larger issue than that, and the closure of state facilities for the mentally ill. So some of the issues that I could possibly think.
It has been taken up, and I could have got a very problem.
Yeah.
A lot of promotions that we have.
Yeah. So we look at it a bit closely, because I think it's an area of neglect. Lawyers have traditionally neglected this area, almost 100%, except for stray cases here.
I think I'll just respond to the question of the doctors also doing pro bono work. The reality is that there is a real lack of professionals dealing with psychosocial disabilities, whether they are psychiatrists, clinical psychologists, or nurses trained in specialized in the psychosocial subject of care. And the ratio of a doctor to the number of patients is just extraordinarily high. So, the access to professionals dealing with mental illness ailments in prisons is very, very poor. There is one in the heart, as I said, but I think there are many prisons where there's not even a full-time psychiatrist in every jail. So that is a problem. And yes, the other thing, that integration, you have to look at disability, you have to look at it from an inclusive perspective from the very beginning. If you don't, then they remain segregated, your attitude to them remains segregated, your services to them remain segregated, and they remain completely outside the system at every stage and at every level. So that attitude change has to come in the way we perceive and include disability in everything that we do, and especially in policy.
One is about the lack of staff. So that can be helped by making, even in the prison setting, we are looking at training the prisoners themselves and making them barefoot counselors. So that kind of innovation is possible. So, and also the warders, when we supplement them, they can also form counselors, so that the burden on psychologists and psychiatrists less, and also there's a impact. Second thing about closure of this thing, in India it's more like there are not so many tertiary centers anyway. So one thing that we are looking at foster homes and shared housing. in the thing, so that it becomes an open system rather than a closed asylum psychiatric thing. So even in the jail, we are looking at that kind of system. So the both can kind of work in tandem.
And we also did in the Supreme Court the case on Asha Kiran, where we mentally ill girls. And that was like a horror story which you cannot believe, you know. All the girls lying nude, all of them lying in their pieces. Why? Because they are mentally challenged, they don't know how to keep it. It was unbelievable. That's not this come from the Supreme Court. So the mentally ill issue is one of the largest issues. And it's just not one PI. It's a battery of PIs that we should do, different petitioners, different advocates, and take it up in the court at a very high level. Thank you all very much. It's been a lovely.
बात करनी मुझे मुश्किल ए दिल कभी ऐसी तो न थी जैसी अब है तेरी महफिल कभी ऐसी तो न थी. This was my first instant thought when I was told that I have to speak and share my views with such distinguished guests, such learned people all around. Thank you, Collins, for this opportunity. And then what to speak on was another dilemma. I thought I'd speak on the legal principles, the statutes relating to the women prisoners and the children of women prisoners and its enforcement in the court of law. And then I said, no, this can't happen because we have very distinguished judges and academicians, Dr. Murthy, Professor Raghavan, eminent lawyers and judges, so therefore this is not something I should speak on. Then I thought, okay, let me just then talk about the prison policies. What are the prison policies which are right in its place and the prison policies which are not right in its place? For example, semi-open prisons and open prisons not available for women all over country except for a few jails which are 4th jail and 5th jail, of course, thanks to which is we looked out 5 this PIL. Then I thought, no, this is not a subject for me because we have such eminent speakers on prison who are experts on prison law, who formulate the policy, who enforce the policy. We have Dr. Bedi coming day after, we have our DG coming day after, then Mr. R.P. Singh coming day after. Then I thought, okay, I'll talk about PILs. And then I said, of course not, we have a PIL champion, Colin Ghazal sitting here, so I cannot talk about PILs either. Then I decided to share 3 short, true stories, very short, all true stories of women prisoners. Those cases I have personally handled. And with those stories, I would want each one of you to be left with some food for thought so that collectively we can think and we see where is the problem, what is the problem, do we have a solution to this? I am sure we do. So the first story, since they are all reported cases, I take the liberty of naming them. If they were not reported cases, of course, their privacy would have been very dear to me and I would not have named them. So the first case is of Janshiri. She's still in jail. The prosecution version was that she had killed her husband. Prosecution admitted that she was the battered wife of a person who was an alcoholic. She had 4 children from him. The eldest was the daughter, 15-16 years old, and the youngest was the son, who was 5-6 years old. And she was battered day after day, night after night. One day when she couldn't take it, and probably she was being humiliated, the boyfriend, and by the way, the so-called alleged boyfriend was half her age, I don't know why, but the police seems to be fascinated with putting a sex angle to every case wherever, especially in times of passion, be it Arushi, be it Janshiri, in jail, whithersoever way. So they said, out of 4 children, the 3 children supported their mother. They said we were sleeping and she was not the one involved in killing of her father, except for the youngest son, who was then 5-6 years old. His statement was like half-baked. मैं सो रहा था रात को, मैंने अपने पिताजी की आवाज सुनी, मैं बाहर आया, वो आदमी कुल्हाड़ी लेके खड़ा था, मेरी माँ साथ में खड़ी थी, मुझे पता मेरी माँ ने मारा. The court accepted his version, convicted her for life. The court thought that it's a good case for conviction because the motive is there because she was battered. Sorry, but the court missed out the point of grave and serious but sustained provocation. Because we do not have the legal concept of grave and sustained provocation. We only have grave and sudden provocation, which is why my objection number 1. Can we have the same policies for women prisoners so large. And the courts need to have the wisdom. Where the admitted case of the prosecution is that day after day and night after night she was battered. She was not even admitted to bail. So, if any one of you must have seen that movie To Provoke, in which Aishwarya Rai was the heroine, and it's based on a true story of a lady in London who, after being battered over years, killed her husband, and we all applauded. We said, yes, that's the justice. But here, no bail, no acquittal. We'll come to the policies and the lessons learned later, but this is story number 1. The story number 2 is Madhubala, which Dr. Sandeep also mentioned about halfway home, which is, in this case, the prosecution version was that she had murdered her husband, gravely injured her stepdaughter, and killed another stepdaughter, and without changing her clothes, she was found sitting on the stairs. The prosecution admitted there seems to be something wrong with the woman. But though we have a facility and the legal provision that within 48 hours, unless the inmate speaks about the brutalities and the excesses done by the police, there is no provision for a composite medical checkup. Now, of course, with the PIL of Baitullah prison, we have that a woman who either herself tells or is suspected to be pregnant, her medical examination, gynecological examination has to be done, and she has to be given the discretion to choose and write over her body to see whether she wants abortion or not. But that we are digressing. The moot point was nobody could make out that she was a schizophrenic patient. And now schizophrenia is one disease which the symptoms may take some time to appear. It's an incurable disease. You have to put it on hold with medication. So nobody discovered, the trial was completed. Had we discovered this earlier that she was a patient and a schizophrenic patient, maybe the entire course of trial would have been different. I filed an appeal after she was convicted, and then it transpired she's schizophrenic. She was enlarged on bail, but the family did not want her back. Now the problem arose, where to keep this woman? The family didn't want her. It's not even safe for her or even for the co-prisoners to keep her in the jail, because schizophrenic patients can kill themselves, they can kill somebody else, and they can be a potent risk to their other inmates. So thanks to the Delhi High Court, the High Court in collaboration with the government, with Mr. Sunil Gupta is the amicus in that case, I am the lawyer from Madhubala, and we had the collaboration of Vibhas, the courts directed for setting up of halfway homes and long-way homes. We have been told that 4 halfway homes have been settled in Delhi. It's unbelievable that though this report is there on paper, in one of my another matter, in which she was named Poonam, another Poonam, I'm talking, the third story is also a Poonam. When she was sent to that Navkiran home, they did not want to keep her because they said, हमने halfway home तो बना दिया, but हमारे पास कोई staff ही नहीं, हम इसको संभालेंगे कैसे, हम इसको खिलाएंगे कैसे, हम इसको medical care कैसे देंगे, हम इसको extra curricular कैसे देंगे. So that's the situation. So I wonder, काश ये होता तो क्या होता, काश वो होता तो क्या होता, तो काश अगर उसका medical checkup उस time पे place पे होता तो क्या होता. That's another moot question with which I will leave my audience with. Now, those halfway homes, of course, has been now that place has been also turned into, has been bifurcated into a PIL. So now the PIL on those halfway homes will be heard separately, and that case, of course, separately. The third true story is about another girl, Poonam. The prosecution version was, this is another Poonam, not the one that I mentioned. Again, a murder case. In this, the prosecution version was that her husband and one of her brother-in-law had gone to Haryana to get a cow, and she was being nagged by her mother-in-law. She could not contain that irritation, and she took a hammer and she killed her mother-in-law. Now, the husband promptly files a divorce petition. At that point of time, she had 2 children, daughter aged 2 years, son aged 4 years. The husband, even the way our courts at times look down upon those women who are actually the victims of the atrocities of their male partners, and the kind of in their subconscious minds, the kind of hatred or dislike or that we want to punish her is so heavy in the subconscious minds of even our judges that ended into conviction. Again, my thanks to the Honorable High Court. The Honorable High Court not only acquitted Poonam, but the Honorable High Court said three things. Yes, I conclude into this. Said three things. One, can we imagine the plight and the trauma of a woman who has been separated from her 2-year-old daughter and a 4-year-old son? Then R.D. Upadhyay's judgment also did not come to rescue because the father was outside, had the custody of the children, and even she also thought that why bring the children to the jail or even for meeting. The High Court made another very important announcement, and the High Court said we have to think about the rehabilitation of such women because you cannot just initiate courses like कि उनको पापड़ बढ़िया बनाना सिखा दो, उनको ब्यूटिशियन के courses सिखा दो. Everybody cannot have that kind of learning acumen कि सिर्फ पापड़ बढ़िया से वो सीखेंगे. Neither can everybody go on to computer, but please open other avenues for them. Vocational training के लिए nursing सिखाओ, क्रेश संभालना सिखाओ, stenography सिखाओ, कुछ elementary education दो. So the High Court gave a big way, but three things which I want to ask. क्या ये नहीं हो सकता था कि हमारा legislation, despite Mullah Committee report, which says that we need special provisions for women as far as sentencing is concerned. In fact, our CRPC provides that women have to be specially considered for bail, but in center practically applied. तो ये नहीं हो सकता था क्या? ये नहीं हो सकता था क्या कि हम उनकी रिहेबिलिटेशन के लिए सोचें और कुछ चिल्ड्रन की स्कीम के लिए सोचें? क्या ये नहीं हो सकता था कि हम उनके पूरे मेडिकल चेकअप्स के लिए सोचते? आज भी in Sheila Verse, one of the directions was कि the MM will require the prisoner or the inmate when he is brought to the court कि कोई तकलीफ तो नहीं है, but invariably आप जाकर के कोर्ट में 2 घंटे बैठे हैं, देखें काम कैसे होता है, क्योंकि courts are so heavily burdened. MM will never get a chance to speak to the inmate. वो कई दफा काम करके resign अंदर कर जाता है चेम्बर में, the inmate is brought and the warrants are signed and the person is taken back. But I being a die-hard optimist, another 60 seconds I know. I being a die-hard optimist, I know we have come a long way and there is no way when we can collectively think and work, we cannot achieve other milestones and we can't walk miles ahead. We can. हमने जब हुसैन आला खातून में इतना टॉर्चर था, सुनील बत्रा में इतना टॉर्चर था, तब भी तो we have come a long way. We still have a long way to go and I'm sure we can go. I want to end up with one line. कौन कहता है कि आसमान में सुराख नहीं हो सकता? एक पत्थर तो तबीयत से उछालो यारो.
So, okay, die-hard optimist, that was a wonderful presentation. 2 points I want to flag. One is the battered woman syndrome, actually, which is prevailing in many countries. We should try and use it again. When a woman kills her husband, who has battered her again and again, the defense that she was a battered woman, that she suffered from battered woman syndrome, is a very good defense which has never been taken in India. I don't think there's a single judgment.
I did see this,
But is there a judgment?
yes, I do. Yes, there is a
Okay,
judgment.
okay.
The court did not accept it.
Court did not accept that, but where the court accepts. The second is, Anu, this grave and sudden provocation, I think it's worthwhile challenging the constitutional validity of the word sudden. Because grave and sustained provocation is equally mitigating or a ground for, not accepting.
So much of mental illness.
Yes. Yeah. In fact, grave and sustained may be even more serious than grave and sudden. And now, yes, Ranveer.
Good afternoon, everyone. I am Ranveer Tukar from Society for Promotion of Youth and Masses, based in Vasant Kunj. So we are working mostly with one of our main focus areas is juveniles in conflict with law in addiction. So our work has to do with de-addiction and rehabilitation of youth below the age of 18 who are in conflict with law and are found to be suffering from substance use disorders or are at risk of suffering from substance use disorders. So our interventions, although we have been working in the field of de-addiction and rehabilitation for 3 decades now, our work with those youth in conflict with law started around 2011, whereon by the then Honorable Chief Justice of India, keeping in mind the rising crimes among children, among those children in addiction, we were asked to set up a juvenile de-addiction and rehabilitation center at Seva Brigade Complex of the Department of Women and Child Development in Delhi. So, like I was saying, this facility is a very unique. It is the only center in South Asia which is catering exclusively to juveniles in addiction. And over the past 6 years, we have catered to over 3,000 boys under the age of 18 at the center. If you just go through some of the services that we are providing, we look to provide a peer-led intervention where most of the sessions are taken by peers, by other recovered addicts and other people who have gone through the program, apart from our own trained counselors. And our main focus, apart from just counseling, whether it's at individual or family level or group level, we focus a lot on life skills because those are coping skills, coping mechanisms which they lack but they need once they go out back into the world in order to prevent relapse and falling back into the habit. As you can see, some of the other main services that we are providing, another main focus that is on vocational training and placement for jobs, because it's been found another main reason for relapse among these boys is once they go out, they have nothing to do. They do not have the skills needed to get a job, to earn a livelihood, to get some respect in their society, in their community, which is something we have found very important to them. So, vocational training in areas like plumbing, in electrical wiring, and most recently food production, where we now are running food carts which are being run by these boys who come out of our centers, and that is helping them earn a livelihood. These are some snapshots from our Juvenile De-Addiction and Rehabilitation Center. There are some counseling sessions, there's a life skill session on sobriety management and relapse prevention. These are some other activities that we do. You can see literacy, then we got computer training. That's a picture of a food cart that, which recently we have now got permission even on the OHP1 Seva Kutir complex, the juvenile court, on the court premises, we are running 3 carts. And this is really helping these boys, once they come out of addiction, once they complete the program, this is helping them, gain skills and get a job and earn a livelihood, which is playing a big role in them not falling back into crime. Because we've seen, once these juveniles come to us, while they're in the center, they go through the program. And once they go through the program, and they're with us for a minimum of 90 days, which usually is not extended a great deal. But a main problem that we get is once they go out within a month, 2 months, maybe 6 months, we see that child has come back again. And when we speak to that child, we hear that, sir, when we came out of your center, we really wanted to do something with our life. We do not want to go back into this problem again. But once they have gone back out, they fall back into their old habits, old crowd, peer pressure, family situations. A lot of these children come from very disturbed backgrounds, and all of these contribute to their criminality. So, vocational training and life skills, these are the two most important services we have found which are helping keep them off drugs. A second very important intervention that we are running, this was around a year old at the request of Tihar jail themselves. They wanted us to do an intervention with young offenders between the ages of 18 to 21, lodged in jail number 5 and 7 of Tihar. So this is a very unique program that we are running over there, where we have 2 or 3 counselors who go there on a daily basis, but they are not the ones doing the main job with the inmates. We are conducting sessions and training peer educators amongst these young 18 to 21 year olds, and they are being sensitized on substance abuse, the need for prevention, on services that are available, linkages outside jail once they come out of jail. And these sessions, once we've done that with them, they go on to the barracks and they conduct these sessions in turn with all the other inmates who are in there and look to motivate them on the importance of, on awareness about the dangers of substance use and the impact it can have on their lives. And in the past year, we have had almost 2,000 sessions conducted by these peer educators in Tihar. Another center that we are running, this is another very unique center in the country. This is a de-addiction center for drug-dependent women and adolescent girls. Now, here we have girls referred to us both by the Child Welfare Committee as well as by the Juvenile Justice Board. So, unlike the previous center that I had shown you, that was exclusively for juveniles in conflict with law, where children were sent by the magistrate. In this case, we have Child Welfare Committee sending us girls found on the street at risk, the Juvenile Justice Board sent us girls, and also we had linkages with other NGOs who bring out women who are in addiction, living on the street, vulnerable to crime, vulnerable to being exploited, and this center is a very, like I said, it's a very unique initiative, and we have made quite a lot of progress. Like the center has been running now for around 1.5 years, and as you can see, the main services which we are providing, literacy, life skills. Life skills is the main focus of all of our programs because these are the main coping skills they need once they go out of children, and so that they don't relapse. We also have a lot of pregnant women who come here, either pregnant or those who have infants. So prenatal care and antenatal care are also very important components of this program. Because when we take in a lady, we have to take in her child as well. And if we don't provide services to the child, we will not be able to provide adequate services to the person in question. Then some very important sensitization programs that we're doing. I'll just quickly take you through this. These we are doing like at the request of the Honorable Juvenile Justice Committee. We are conducting trainings, sensitization programs for police officers in Delhi. This is on substance abuse and how to manage the same when they find children who are indulging in drugs. The main focus is of course on the dangers of drug abuse and also importantly the legal provisions associated with this menace. In terms of the Juvenile Justice Act, Section 77 deals directly with drug abuse among children, sale of intoxicating substances to children below the age of 18, and I'm happy to say thanks to the advocacy by SPYM last year, an amendment was made to this act whereby thinners, whiteners and other similar products which are sold in stationery shops are also now banned from being sold to kids below the age of 18. These are just some pictures of sensitization programs we've done. These are with police. These are for trainings for paralegal volunteers from Delhi State Legal Services Authority on drug addiction and legal issues. And finally, awareness programs in schools. This is probably the most important thing that we're doing because the importance in terms of prevention is always to catch them young, and hence intervention at school level is extremely important when the mind is still willing to learn and it is and can be influenced. So, in association with Delhi government, we are doing every year. We've been doing this for the past 7 or 8 years. We cover around 150 schools every year, and we also do this apart from children, also for teachers and principals on how to recognize signs and symptoms of drug abuse. That's pretty much all. This last slide here. Our focus always is to catch them young before they fall into crime, before they get caught into the vicious circle of drugs and crime, because as we know, they are both linked with each other. Demand for drugs leads to crime and vice versa because of the expenses that these children have to pay every day.
Before I go to the topic of juveniles, this is a prisoner's right training, and I'm being an advocate, hardcore defense lawyer, and all of you are advocates. Most of the lawyers are here and activists. We would be focusing this is a prisoner's rights training. So we would also be using certain tools. We will be recognizing certain tools which you can use in your practice, so that you can be a change maker. You can change certain things which is happening around you. You have seen my colleague Anu is speaking about women's rights, women's issues. Believe me, my interaction in jail number 6 and Manipuri 16, whenever I visit, I find more than 10 to 15 women coming and interacting with me, having issue of battered women's syndrome. This is an important issue, and sir, we should be taking up perhaps with your guidance in the PI. The second is, majority of them are facing a problem. As Anu said, women and men are not equal in this situation. If a person, male is there, please don't get offended, my brother, male colleagues. The wife is running around in jail and courts. But when a woman is inside jail, my experience with interacting with the inmates are, they are aloof, nobody is coming and taking care of them. Because the children they don't know. So many of the lawyers who are here, one of the tools which is being used by them is filing application in the concerned court about the meeting of their children. And I think this can be used by all of you in your respective jurisdiction, because that is biggest pain which they suffer when they are away from child. Because up to 6 years at a particular age, they are allowed to bring them in jail but otherwise they are not. Many other rights you have been hearing since morning, that the women and other prisoners have rights. Similarly, we also came across that the women were having issue with respect to number of sanitary pads. Yes, that was taken. So these are the certain rights when they are not being implemented in prison. Your intervention, you being a lawyer, be a change maker. File an appropriate application through legal aid or through your own NGO or through your own organization. And I think that can change their life and it can help them. Then I come to the session with respect to mentally ill also. We talked about the session was there. But many of the women or inmates, they don't know what rights do they have. So whenever you are interacting with them, you can tell them. And some of the persons say that they can't speak. They are sitting in the court. They don't know if they are allowed to speak to the judge. When their evidence is happening, they don't know that they have to be standing next to lawyer. They should hear because the cross-examination by the defense counsel or any other person. They should know what is there because they are the best person who is knowing the facts of the particular case. Now let me come back to the topic which has been given to me. This is really one of the important issues which has developed a lot post Nirbhaya case. If you know that the Juvenile Justice Act 2015, child below the age of 18 years as per the Act, the defined definition. Some significant changes came post Nirbhaya incident, and the idea of this Act is the duty of the state to protect minors or juveniles. Therefore, if the crime is committed by a juvenile, he should be tried differently than as an adult who commits crime. So when a child alleged to be conflict in law is apprehended, many of you might be knowing, but some of you are very young. This 2015 law is recently passed, and still many states has not implemented, not framed the rules. The rules are still in progress. He should be placed when a child is arrested, conflict with law is arrested by the police. He should be placed under the charge of a special juvenile police or designated child welfare police officer who shall produce this child before a juvenile justice board. And an inquiry may satisfy a board that a child, irrespective of age, has committed a petty offence or a serious offence, or a child below the age of 16 has committed a heinous offence. In such case, it may allow the child to go home after advice or admonition. Direct the child to participate in group counselling and similar activities, order the child to perform community service, or release the child on probation, and or direct the child to a special home, not more than 3 years. So these are the procedure which is outside. Now, when you see, there is another distinction which has happened recently in the latest law, which is the Act allows for juvenile 16 years or older to be tried as an adult for heinous crime, like rape and murder. Heinous crimes are those which are punishable with imprisonment of 7 years or more. So now, the juvenile can be tried as an adult, depending on the heinousness of more than 7 years of offense, punishable offense. Then, what is the procedure normally taken care by as per the Act for arrest? As soon as the juvenile is apprehended, he shall be sent to the juvenile police unit or the designated child welfare officer, and he should be produced before the JJB within 24 hours, excluding the 9 necessary for trial. An FIR, as you all know, that no FIR or a charge sheet shall be completed regarding a minor except for serious offences such as rape, murder, or crime committed jointly with adults. And that has to be the information pertaining to that alleged offence has to be recorded in daily diary along with the report including social background of the juvenile and circumstances of apprehension. Bail, here in these cases, you know, most of the time the bail is granted. While the procedure is pending, the investigation is going on, the principle is that child shall be released on bail, with or without surety, or placed under supervision of probation officer or any fit institution or person. If there are reasonable apprehension or grounds for believing that the accused child is likely to be reoffend or that release would expose him to moral, physical, or psychological danger, then the bail may not be granted. With respect to assistance, counseling, many of you know that there are special homes for juveniles. The child, minor involved in criminal cases, will be incarcerated in juvenile special home only, not in adult prison. I'll come back to the issue where we find a lot of juveniles in adult jail, and there are certain guidelines by Delhi High Court. What are the sentences which for the juveniles that the court may pass, the juvenile board? They may allow the child to go home after advisory recommendation, community service, payment of fine for the parents, or the juvenile if he is over 14 years of age and earns money, release on probation of good conduct under the care of a fit institution for a period not exceeding 3 years. Then there is a provision regarding rehabilitation of juveniles. Now, basically, these are the tools which I wanted to share with you. The famous judgment of Abuzar Hussain, State of West Bengal, by the Honorable Supreme Court, says that juvenility claim can be raised at any stage. I think most of you know that this, even if he has not taken the plea at trial court, it can be at an appellate stage. Even the final dismissal of SLP, thereafter also this can be raised. However, to raise a claim of juvenility, a probable case, a prima facie case, a little bit has to be made by the person. Documents, if there is a matriculation documents, and then municipal records, and in the absence of any other record, then there is a medical provision. Then, in Bablu Pasi, the court says that the accusers failed to produce certificate in support of this claim, medical can be called for. Shah Nawaz, State of Uttar Pradesh, the court examining the scope of Rule 12. Rule 12 prescribes that the high school certificate, municipal record, and in the absence of none of those records, then you can have a medical ossification test, a medical board opinion. Then the other question was, many times, because if you see that even if you are not in the juvenile courts, and I think many of you are interacting with the trial courts, where your client says that he is a juvenile, and he is raising a claim, court should not conduct a trial of that inquiry. This is an inquiry. The Ashwani Kumar Saxena judgment clearly makes it that the court should not do a fish hunting like a trial. It's a basic inquiry. You inquire the documents, you inquire any other probable cause that this person is a juvenile, then consider his claim of juvenility. Sampurna Bairwa, again, this was with respect to implementation of JJ Act. Still, I think Collins sir's, the credit goes to Collins sir on that regard. The child-friendly, the court should be child-friendly courts. And then, the important thing which I wanted to share with you is this judgment of Delhi High Court. This is a writ petition 889, and one of my brother and colleague, Anant Asthana, who is nowadays working more on juvenile laws, has assisted the court, and we also find intervention. Certain guidelines has been issued. If you remember, the DK Vasudeva implemented the arrest memo. With this judgment, with this order, the Honorable Delhi High Court implemented a direction to the inquiry officer, to investigating officer, to send an age memo, which will reflect that the age according to the inmate, according to the juvenile or his parents, that basic inquiry will do along with when he is sending the person to jail. And for the persons 18 to 21 years, it is made mandatory in this judgment. And there is a direction that the jail authority may refuse to take person if there is a no age memo. So this has really helped a lot after that judgment, we found that in jail there are not much of juveniles. But if you find any of the person, you have to inform them, because most of the people, especially the police officers, in order to avoid the distance that the Juvenile Justice Board is at far place and the trial court is close by, he'll write his age, person is of 16 years or 14 years, he'll write age 19 years or 20 years, and then send him to the adult jail. So this is not acceptable. Even the Supreme Court has clearly talked about it, and the age limit in Delhi jurisdiction, and I am sure coming period the Honorable Supreme Court may also pass directions about this age limit for all over India. Thank you everyone with respect to this session, and we'll take questions after.
Hello everyone, I'm Palak Chaudhary and I work with Commonwealth Human Rights Initiative in the Prison Reforms Program as the project officer. My primary work deals with foreign national prisoners. Now, I'm sure because all of you are practicing day in, day out, you must have come across foreign national prisoners. But sometimes there have been instances where lawyers have contacted us with regard to foreign nationals because they do not know how to proceed with it. And so we will talk about the issues first and then how, as lawyers, you can deal with it in your practice. So there are a number of issues that foreign nationals face in India particularly. There's 5 of them. First being access to justice. The problem with foreign nationals and access to justice is that they do not know the legal system of India, and so when they fall into the system, they're left helpless because sometimes their embassy also does not come to support them. So, and Section 14 of the Foreigners Act, which mandates the detention of anybody who comes without documents. Now, the law is a little different beyond the borders of India in foreign countries, but in India, anyone who is there without documents is sent into detention centers, and that is where the whole Rohingya matter comes in, which I'll discuss further. There is discrimination, so a foreign national cannot get bail or parole unless they have extremely solid documents to prove it. Then there's language barrier. I can personally tell you about 2 instances. One was an instance that my colleague had addressed. There was a Bolivian lady in a prison in West Bengal, and her family was looking for her, did not even know where she was, and they were not able to reach out to her obviously because her phone was dead. And the language barrier was there because she was speaking Spanish and nobody at the prison spoke Spanish. Nobody even bothered getting a translator. At the end of it, my colleague went there with the Google translator and managed to understand what she was trying to say, get family details, and inform her daughter about it. And her daughter was relieved to know that her mother was still alive after 6 to 8 months. So this is the problem that we are facing. Then I can tell you about another instance where I met with a Nigerian national, and he, after I had a conversation with him, he said that this was the best conversation he had had in the past 1.5 years, because when he was in prison, apparently all the Indians there were harassing him. So he said, I'm such a tall man, I could do something, but nobody wants to have a nice conversation with me. And this was the first conversation I had with anybody in 1.5 years. So it does take a big mental toll on everybody who does not even get to have a proper conversation. Then there is the immigration status. You either get imprisoned or you either get deported. Then there's the culture and religion. Culture and religion would be important because family ties are important when somebody is trying to rehabilitate themselves. So if they do not have access to the families with regard to calls or video conferencing or personal meeting, then it can take a toll on them rehabilitating themselves. So I had filed an RTI nationally in every state. We have gotten responses from most of them. Some of them are in the appeal stage. But I have a data of 3,895 foreign nationals in prisons across India, of which there's 1,647 undertrials, 1,377 convicts, 871 awaiting repatriation after completing their sentence. Of those, the maximum time a person has overstayed is 12 years after completing their sentence. Now, if we look at the consular access, how many of them have received consular access? Of the total of 3,895 foreign nationals, only 5.7%, that is 222, have received consular access. Even though under the Vienna Convention, we have acceded it and so we're supposed to provide it, but that is obviously not happening. This is a flowchart that you can see. This flowchart represents how the information of a foreign national would get communicated to the embassy and how the embassy should be kept in the loop with regard to how the case is proceeding and when the sentence is going to get over, because they're the ones who are going to issue the travel permits. So it's very important that they're kept in the loop. But that is not happening either. So after we got the data, we started reaching out to embassies to ask them if they had the information, and if they did not have the information, then sharing the information with them. And so that is when we realized the problem with all the stakeholders in the entire system. So the entire system comprises of the State Home Department, the Central, the MHA, the Ministry of External Affairs, there's the Embassy, the Police Department, the Prison Departments. There's everyone is involved with just that information getting communicated to the embassy, then to the family, and then getting to know if they're willing to pay the fine and who's going to pay the tickets. And there's a huge, long process with that, which I would be delighted to have a conversation with later if anyone's interested. And so the first point you can see is embassy is informed of the foreigner's arrest and documents such as passport and FIR are sent. That is not happening. So when I've met with 3 different embassies so far, the Nigerian embassy, the Bangladesh embassy and the South African embassy. I shared a data of 2,500 Bangladeshis with the Bangladesh embassy and they only had a data of 700. The Nigerian embassy had an information on 54, I shared 240 with them. And the South African embassy had an information of 4 and I shared 12 with them. So you can see that there's a huge demarcation between the information being shared and the information not being communicated because it's getting stuck at one of the offices on our end. So with that I said, and that I said as well. Okay, so asylum seekers, refugees and migrants. Now, a lot of times there is a misunderstanding as to like everyone who comes from outside does not have documents. Section 14, they're put behind bars, Foreigners Act. But no, there is a difference between all of them. So an asylum seeker is someone who fears persecution in their country because of the 5 reasons in the international refuge law, and they come to another country to seek asylum. Once they are granted the status of asylum, that is when they become a refugee. And an economic migrant is someone totally different from that. An economic migrant would be somebody who is seeking out assistance with regard to just trying to get financial benefits. They're not fearing persecution in their country, they just came because they want to improve their financial conditions. So these are the provisions that govern the repatriation procedure in India. And so there's, okay, for those who do not know, interesting fact, if you have been charged with an offense in a country and you have a bilateral treaty with that country, you can be sent back to your home country and serve the rest of your sentence. So there's about 32 countries and a few in the pipelines with whom we already have bilateral agreements, some of whom are like Nigeria and Bangladesh. A lot of stakeholders in the process do not know that this agreement exists. Now the purpose of this agreement is on humanitarian grounds, that a person would be able to go back home and serve the sentence in their home country, where the food diet would be according to their choice, the language would be of their choice, they could meet their family members, they could call them, they would be with their people and not feel discriminated against, which happens a lot in India. So this bilateral treaty, I'm sure a lot of you must have read the newspaper, there was one successful case of the Bangladeshi being transferred for this sentence, but it is not happening as often as you would expect it to happen, because that was a one-off instance and there's like 2,500 languishing in prison. And so these are the steps that one has to go through to be able to achieve that transfer to their home country. So there has to be a no objection certificate from the concerned state government, a report from the Intelligence Bureau talking about if there are any further consequences possible, comments from the agency that arrested him and charged him, would the sentence require adaptation. Sentence requiring adaptation would mean that if in my country the offence is charged with 5 years and if in your country it's charged with 7 years, a committee would sit and decide if the person will serve 5 years or 7 years or maybe 6 years. Then there's coordination meetings, willingness on part of the receiving country, and handover and repatriation. There are a few Indian case laws, but I would like to bring your attention to the first one. The deportation to take place within 2 weeks, prisoner to be transferred to detention centers within 1 week, prisoner to be issued long-term visa and identity certificate if the nationality cannot be ascertained, cases to be referred to the United Nations for third country resettlement. Now the interesting part here is even though the judgment says that, it's not happening in practicality. I have personally met somebody who's overstayed their sentence and is in a detention center in Alwar for 12 years. So there are these 2 case studies that we had. Can I take 1 more minute, please? Thank you. So there are these 2 cases that our team has dealt with in the past. The first one being, so these 2 cases actually shed a lot of light on the procedural system of India. The first one being of a 60-year-old Afghan male, we won't be using names, and he was charged with the NDPS Act and arrested in 1999. He should have been in 2012, but was repatriated in 2015. 3 years overstayed. Why? So the problem here was that for 3 years he had to pay a fine. So the government did not allow him to pay the fine. They wanted someone from his family to come and pay the fine. So his son, who had already with his family already taken the street, family they become beggars, had to somehow manage money, come to India, take the money from his own father, give it to the government, and then take his father back home. Do you see the picture here? The person is already in such a bad condition, has stayed in the prison, has served their time. You make them stay for 3 more years and still choose to not send them back. Case number 2 is of a Palestinian national who was 50 years old. Another really long procedure. The procedural flaw here was that in 2013, after 1993 when he was arrested, in 2013 they started to look for the passport, which was 20 years later. And so obviously finding the passport is what took the longest time. It took him 2 years to find the passport, which was in a Malkhana in Nagpur. So the entire procedure was stalled because the officials involved did not know the passport. And so this is a few things that the lawyers can do on their end when they come across the case of foreign nationals. So at the time of arrest, you can inform the embassies of their citizens' case and status. Ensure that nationality verification takes place because only then can consular access be provided. If the family is not aware, then maybe inform them. If you notice an absence of consular access, then notify to the court. Then at the stage of trial and custody, ensure that consular access has been provided. Then keep the client updated with their case status, which everyone should do for every case, but more here because they have nobody else to rely on. Ensure there are means of communication established between foreign national prisoners and family. A few states have come up with their conferencing options, like Himachal Pradesh or West Bengal is about to come up with it. Delhi has come up with regular international calls. If persons claim that asylum seekers or refugees, then the lawyer would have to take appropriate steps to get them RSTs possibly from the UNHCR. Conviction, enlighten maybe your client about the sentence transfer if they're not aware of it already. And when they're coming to an end to their sentence, make sure that their travel permits are issued and the nationality has already been verified because that is a 1-year process. And post completion of sentence, if the period is complete, then arrange for the FRRO and the passport office and the funds that have to go into it. That's all. Thank you.
Okay, 5 questions and 5 quick questions, 5 quick answers. Or comment. You can do a comment and then an answer.
So you were talking about test of a battered woman. We are following a reasonable man test of KM Nanavati. So how is it possible? Like we have completely outruled that. Section 8 of IPC says that he includes C, means women. 10 again says that man is male, woman is female, and still we are stuck with that reasonable man test. So still, what I feel that we need to look upon on this. And secondly, in juvenile, the new juvenile law, I did my dissertation on that in Delhi itself. And what I found that according to Section 107, that special juvenile police unit should be there. And what is happening when they are making arrest of children who are 16 to 18 years of old, they are not, the custody is not being sent to the police officers who are in special juvenile police unit. They are being given to the others, like those who are investigating officers in serious matters. So there, that is one lesson of what I got. And another observation, what I got. Sorry, I'm taking so much time. So in my field work in Mumbai, what I felt that we visited 3 police stations, and none of them in this special police juvenile police unit was not made. One of them was Kalyan police station, which is a model police station. So that's it.
Thank you, sir. That's a comment. It doesn't need a question. Really, miss you. Right, please. Why don't you go at once? Go quickly. The 3rd person is up there, so you give it to him, please. Indrajit. And the 4th person is here. Yes, sir.
My question is to Dr. Rajesh Kumar. Sir, you spoke about if I read it correctly, your organization had worked on minors and juveniles. So when you said that when you have worked with the children for 90 days and they have come back to you again, and the major problem in rehabilitating is that they have worked with, they have been with very disturbed family backgrounds, so they go again to drugs and to other things later. So how do you deal with that? And have you worked with real hardcore criminals like gang rapists and all? Do you think it is a way to rehabilitate them? Is there any way?
Yes.
Thank you. Indrajit? Just hold the question, then we come. Indrajit?
A very big problem which is happening is that many Indians do not have any proof of their citizenship, and even they are being taken in for Foreigners Act. So this is being a burning issue if we would have a greater study on this point.
Yes, Indrajit comes from West Bengal, so this whole Assam issue is in front of him as well. Just one second. Sir, you? Mike?
कभी कभी ये होता है कि मजिस्ट्रेट कोर्ट हो या किसी विशिष्ट लेवल का कोर्ट हो, जब जजमेंट निकलता है तो फॉरेन नेशन के जो फॉरेन कंट्री का लोग होते हैं, ये लोग जजमेंट कर देते हैं कि ये कन्विक्शन कर देते हैं। कन्विक्शन के बाद वो कुछ नहीं करते हैं कि वो क्या होता है ना, जो पासपोर्ट एक्ट के अंदर वो आ जाते हैं, 2 साल का कन्विक्शन हो जाता है। इसके बाद प्रोसीडिंग कुछ नहीं लिखते हैं। जब वो जेल से निकलता है तो ये पासपोर्ट न होने के कारण वो फिर इसे जेल भी अंदर करवाते हैं। What is the provision? Little clarify from Madam Palak.
Last question.
Okay, so my question is regarding juvenile system. Now we know that the age of majority is 18 years old. So why is it that we have exactly 18 years of age? For example, I'll give you a classic example of the Nirvaya case. The one was convicted, the child, the youngest one, was almost 18, a little below 18 when he committed the crime. Now the reason I think behind this is because of prefrontal cortex, it develops quite around when you're 18 years of age. But much like puberty, it's not exactly 18. It could be, say, a week before 18 or a week after 18, where you could actually mature into an adult. So during there should be another system to measure your maturity level rather than just your birth date to determine if you are an adult or not.
Whoever tries to answer this question will be given exactly 1 minute. So if you hazard into this area, you have exactly 1 minute. It's an important issue. It's just that we don't have the time to do it. It's a very contentious issue. Just you, and then we go to the topics. Yes.
So my question is to Anu ma'am. You've talked about feminism and feminist-related laws and all that. So my question is not really legal, but socio-legal perspective. How far do you think feminist laws should be stressed upon? Where comes a time when we talk about gender-related imbalance, this is what we exactly talk about. Women-related laws which become biased against men. That's what we see in 498A and other subsections. Thank you so much.
Thank you, everybody. Now we'll start from Anu and go that way. Roughly 2 minutes each, please.
It's actually not a very straight question, but because we are running positive time. One, see, please don't demarcate them saying like feminist law, that these laws really involve the offences done by one category against other. But what I said was that because the problems of women inmates are larger, therefore the measures have to be larger. Here you cannot treat them at par with male convicts. 406, 498 again, this law has been diluted to a great extent because it's specifically based on 406, 498A. Just to quote one simple example, like for example, even those women who have a full-fledged family outside the prisons and they are not accepted back, they have no other place to go. We have no place to send them. Everybody cannot be put into vocational training, so they have no source of earning. They have social ostracization. But with men it's different because they have some sources of earning. Financial independence gives them a lot of confidence and a lot of stamina to resettle and reintegrate themselves into society. Whereas women, then secondly, there are even health issues which are specifically concerning women. Health and hygiene. So the kind of, in the morning session somebody said that now we have the availability of sanitary pads for women, but 2 pads in a day. Then their bathrooms, their washrooms, their clothing, their children, they have to be kept separately. So therefore what I said was, you need to have different and larger measures for them. So therefore that equality. And for 406/498 also, just because the law is being misused, so check that misuse. I remember college having made that statement before. So check that misuse, not scrap the law off. Thank you.
Thanks, sir. There's pressure on us to be at the outside and
I comment to you, as you know, we all are gathered together and there is a purpose for it. And we will be having session for future PIs. And you said in Maharashtra, in Bombay, there was no special juvenile police unit existing. We can file a PI. In Delhi also this happened. With this petition which I have said to you about the age memo aspect, this has changed a lot because it was regular habit of the police officer to send the persons in jail, adult jail, and take it by the investigative officer. Second, commenting to my friend here, the age, there is an international standard to it. International law, UN law, Beijing rules are there, and as a result, 18 is taken as a parameter, and thereafter this amendment which has come into force, post Nirbhaya, they wanted it to be reduced to 16. Therefore, in heinous cases, that category has been categorized. In heinous cases, if there will be the discretion of the court, and obviously that the juvenile can always challenge it, discretion of the court to see that this person is to be tried as an adult. So that is a protection, but the parameter is international standard of 18 years. And one thing, lastly, I would like to say, I think my colleague Palak has commented on foreigners, but when I am visiting jails, the majority of the prisoners, what the problem they are facing is discrimination in grant of bail, number one. Even if they are at par with their colleague, the co-accused is an Indian, granted bail, he will not be granted bail because he is a foreigner. Number two, when a person is not repatriated, he is serving his sentence, he is deprived of basic right of parole and furlough also, because he cannot go there. So that is very important issue we all have to discuss, and I think coming up. And this bail foreigners issue, the Honorable High Court has taken, Delhi High Court has taken cognizance on a letter petition and appointed me as an amicus, and I will be assisting court whether the foreigner should be bail, in what conditions that can be possible.
Thanks, Sanjay. I must say actually the issue of the reduction of the age of juvenility from 18 to 16 in heinous crimes, it really makes no difference. The nature of the crime makes no difference to determination of juvenile at 18. Little difference, small crime, big crime, whatever. This change from 18 to 16, according to me, unconstitutional. And somebody should take a case where a juvenile has been taken as an adult. So challenge that determination. This juvenile is capable of understanding, therefore this juvenile should be treated as an adult and challenge 18 to 16 reduction. That's the fundamental case that should be done. This 18 to 16 thing is a big nuisance, but groups have not gone ahead with any challenge to that 18 to 16. But take it in an appropriate fact case, where a person has been treated as an adult and wrongly treated as an adult. So keep it in mind.
Coming to your question, I think you have two questions regarding relapse, about children coming back, and secondly about housing children that we have to do. So coming to your first question, yes, we do get relapse cases. We have around 25 to 30% relapse rate, which in our bank is considered to be pretty good and successful. So what we do for preventing relapse, one of the main services that we provide is family counseling, where family members are asked to come once a week, and they also have to attend a session alongside the child, because until you can get the family on board, until the family is also supporting what you are doing, there is no real point, because after 90 days he's mandatorily released, and once he goes back he'll fall back into the same thing. So one is family counseling, family intervention, and secondly follow-up. After release, we are not able to do it to the extent we would like due to constraints, organizational constraints, but we do follow up on phone, sometimes home visits. We are trying to get it mandatory that they have to keep reporting to us for 2 to 3 months post-release, but that has not yet been done. Second question regarding hardened criminals, yes, we have had many hardened criminals come into our center, charged with murder, rape, other sexual offences. I actually have a very interesting, tragic yet inspiring story, which will actually combine both and just say like, so there was this young kid who came to us around 14 or 15 years old.
We won't have time for that. You have to make your point now, because we really have to follow that. We won't have time for an example and illustration. Make your answer to the question.
Okay, so your question is that, yeah, I mean, you asked about hardened criminals, yes we do, but for us, see whether it's someone who's coming for pickpocketing or whether it's coming for murder, for us, below 18 child has to be treated the same way, so there is no real that is
yeah.
Hi. सर आपने पूछा था कि अगर पासपोर्ट एक्सपायर हो जाता है और उस बेसिस पे उनको सर्व करना पड़ गया सेंटेंस और उसके बाद बाहर निकले तो उन्हें फिर से सेम प्रोसेस में ले जाते हैं, पर सर वो डबल जेओपार्डी हो जाएगा जो हमारे लॉ के अंदर क्रिमिनलाइज है। और इसीलिए हम बोल रहे थे काउंसलर एक्सेस की बात, जब उनका सेंटेंस खत्म होगा तो उनको बाहर आते समय एम्बेसी एक ट्रैवल परमिट देगी, उनको टिकट इशू करेगी और उनको पूरा प्रोसीजर बताएगी कि वो कंट्री को कैसे एग्जिट करेंगे, एयरलाइन की परमिशन, बस की, ट्रांजिट की, अगर साउथ में है और अगर दिल्ली से फ्लाइट है तो जेल दूसरी जेल में जाने की सारी परमिशन देनी पड़ती है, सारी परमिशन देनी पड़ती है।
Take minister, sir. Now we can't have second question. She'll answer this. You'll have meter over tea break also.
So अगर काउंसलर एक्सेस प्रोवाइड करेंगे, अगर एम्बेसी अपनी तरफ से ट्रैवल परमिट दे देगी तो फिर उनके साथ डबल जेओपार्डी नहीं होगा, इनफैक्ट डबल जेओपार्डी इंडिया में होना भी है। और I missed the question of it. Can you repeat it, please?
The question is on Indians being falsely treated as foreigners because of what stop.
No, that's a separate issue. That's the Assam.
So for that, I think if they go to the Citizenship Act or the nationalization, that could be a possible route. But right now, it's a big political issue. It's not even, law is nowhere, not even touching it.
So this has been a great session. I want to end with one question, and we are postponing the tea break likely, and another session will start. Can a refugee be prosecuted for not having a valid document, passport? How many say no, cannot be prosecuted for not having a valid document? How many say yes, you can be prosecuted? A refugee can be prosecuted. You come into the country like a Rohingya, you come into the country without valid papers. It's an offence under the Passport Act. Can you be prosecuted? Yes or no? How many say yes, you can be prosecuted? Alright, we'll keep this discussion for the evening session. There's a big difference. A refugee can't be prosecuted just because you don't have a passport. In the Rohingya case, you remember the Home Ministry said they have all come without valid documents, so they're going to prosecute them and program. Keep it in mind in the evening session. Thank you very much, and now we move to the next session. Anymore. You'll build jails. That's the American way. Keep on building, and put half your population in jail. But the better way, the best way, is to ensure that unnecessary arrests are not made. To cut down on the arrests being made. Right? And that's what this session is all about.
I think the first point that we really need to look at is the amended section 41 of the CRPC and how it is not being implemented at all by the police. So in a whole lot of cases of people where the maximum sentence is less than 7 years, there is now a specific provision in the CRPC that arrest shall be made only if necessary. But how it is being implemented in complete violation actually. So that is one issue where as lawyers who are working across the country, if you would take up specific cases where you can make it as a case where to find out why was it necessary to arrest this person, then section 41 exists. Because unless and until there is a slew of petitions of this sort, the police is going to continue to arrest everybody, irrespective of whether there is a need to arrest people or not. That's my first point when it comes to unnecessary detention. The second point I want to make is that there has been a lot of focus on 436A over the years, and rightly so. But comparatively, there hasn't been as much focus on 436. And I think there are a lot of cases of people in jail who have been granted bail, and yet they continue to remain inside because there's no surety for them. When I was a part of the Prison Reforms Committee in Maharashtra recently, we asked for data, and we found that there were more than 600 cases in Maharashtra who were eligible to be. They were already granted bail, but it was more than. And the law says that anybody granted bail and more than 1 week has passed, then he shall be considered for release on personal bond. And the funny thing is that the law says may and shall. What does that mean? The magistrate may and shall. I mean, it's worded in such a way that it's the magistrate continues to have discretion to not use the provision of personal bond. There is an inherent bias in most magistrates on this issue of personal bond. They feel that if somebody is released on personal bond, he or she is likely to abscond, and that's the main reason why provisions of personal bond are not being used despite so many directions by the Supreme Court. The third point that I wanted to make was that one can identify cases of under trial prisoners who have not been taken to court for at least more than 2 times. Because now we know that in many of the big cities, people are not being produced on their court dates. And so if we can highlight those cases where they haven't been produced for longer periods, like 3 months, 4 months. I'm saying anybody who's not been produced more than two times, then at least those cases can be taken up, more seriously by the courts, because we have reached a point where if you don't, if you missed 1 court date, it's okay. If you miss 2 court dates, it's okay. That's how the attitude of the magistrates also is. Then there's another thing that needs to be looked at is fine sentence cases. A lot of people are in jail in petty offences where the main sentence is payment of fine, and in lieu of payment of fine, they are sent to jail. So, ticketless travelers, for example, or people arrested under the Bombay Police Act, hawkers, etc. Now, these are unnecessarily crowding up our jails, and the fines are as low as 200, 500, 1000 rupees. So, if those issues can be looked at, why can't these people be released under Section 3 of the Probation of Offenders Act? Which is admonition, release on admonition, or maybe you could identify donors, NGOs, donors who could pay the fine amount, and these people could be sent out. My last point is that if we use the Probation of Offenders Act more effectively, there's Section 3, Section 4, and Section 6 of the Probation of Offenders Act. A large number of petty cases, first-timers, young offenders, all of them can get released under the Probation of Offenders Act. And I seriously think there is a need for a PIL to be filed in the Supreme Court on the non-implementation of the Probation of Offenders Act across the country. There are no posts of probation officers, they're not being filled. Even if they are being filled, they're being used for other things. So these are some of the main points I wanted to make. How can it be done? It can be done by involving law college students, by making prison visits, and writing applications for bail, reduction of bail, release on personal bond, etc. DLSA can organize a quarterly survey inside the prison to identify cases about which I have talked about. And lawyers can tie up with NGOs, because lawyers, number one, don't have time, and number two, don't get easy access. So those NGOs which already have access inside, they can be tied up with each other and try to see more cases can be done. And many of you can get onto the legal aid panel, because that's one way by which you can access the prison, which otherwise is difficult for you. So with this, I'll stop here. Thank you very much.
So I'll continue from where I stopped in the morning, actually, where we were talking about where clearly does the problem come from, where we're talking about overcrowding and under population, but arrest is something that needs to be really looked at. So here I'll be talking about arrest procedures and safeguards. Dr. Raghavan has sort of talked about that already. Remand and bail procedures and access to legal representation. So basically, on an annual basis, there are about 60 lakh to 70 lakh arrests every year. That's a big number. And when we talk about unnecessary detention, the term unnecessary arrest keeps on coming. And the National Police Commission, and this is long back, they said, and probably that holds true right now, true today as well, that 60% of the arrests that are made are actually unnecessary. And therefore, 40% of the expenditure in jails is spent on people who should not have been arrested in the first place. So, we're looking at people who've been arrested, and because the safeguards have not been followed, they continue to be in the system. Dr. Raghavan talked about new amendments to Section 41, so Section 41A, 41B, both are important safeguards, whether 41A talking about whether you really need to arrest somebody when the offence is less than 7 years, or is a notice of appearance okay, and 41B where you need to inform the family of that the arrest has happened and make an arrest memo. And while these are usually not done, it is the duty as lawyers to actually identify if that's happening and actually put that across. With remand and bail procedures, again, Section 167 of the CRPC, where so recently there was a Dutch study which basically said that high courts in general get 4 minutes to actually to hear a case at one hearing. Now, with magistrate courts, that be even lesser than that. So, is that time adequate for a magistrate to decide whether I should remand the person or grant the person bail? Access to legal aid counsel at the time of first production. So, the CASA judgment very clearly talks about the fact that at the time of first production, we need to have the right to legal aid exists, and if it is not provided, then departmental inquiry can be taken against the magistrate. NALSA has in 1998 developed a scheme called, which is usually known as a remand scheme. Maybe some of the lawyers here are remand lawyers. Effective use of liberal bail provisions. Again, as I was saying earlier, so last year the Law Commission came up with a report which seeks to amend certain provisions of the CRPC. And but while you can have amendments, but the existing laws per se can only be useful if they're implemented liberally. Again, these releasing people in person bond, that's something that has already been talked about. Judicial discretion. So, while even if when one is granted bail, what is the surety amounts that are being given? And that's a study that really hasn't been done, and that's something that civil society should really take up to actually evaluate what kind of offences are being by comparing the offences to the kind of surety amounts that are being mentioned by the court. And as again, Mr. Rao mentioned, the Probational Offenders Act, so that you don't really need to incarcerate people. A few years back, we did a brief short study in Jodhpur where we looked at about 60 remand orders, and what we found was that there was not even a single case where the person was discharged by the magistrate or at the first production. Not even a single case where they were granted bail right away. In 42 cases, they were remanded in judicial custody and 18 in police custody. We did further analysis in terms of how many days were they sent to police custody and how often did it happen. I'm not detailing that here. Third element, which is legal representation and legal aid at police station. Now, earlier, Sanjeev Jain from the Delhi SMSA talked about how this model is working in Delhi, but that really needs to be there across the country because right at the outset, when 60% of the arrests are actually unreasonable or unnecessary, you need a safeguard there for somebody to stop that and question whether you actually need the person to be arrested in custody. And we have the Constitution, we have 41D to basically empower and say that you need a lawyer administration. That's something that is very, very clear. With respect to the last 10 years, I'm not sure if you can actually read the text here, but I'll just give a summary of this. So, in the last 10 years across the world, with all the instruments that have come on legal aid, they very clearly said you need to have legal aid lawyers at the time of arrest or even before arrest, but if you're asked for questioning. And so you have the UN principles and guidelines on legal aid, which basically said that the state is responsible to provide, to facilitate legal aid providers. you had then the European Commission on Prevention of Torture said you need to have legal representation at the police station. The UNDP came up actually with a handbook on how do you ensure that there are legal aid lawyers and paralegals at police station. So there's enough guidance and international standard to say that you need to have legal representation. The Indian Constitution says it, but still you don't have the legal provisions and actually framework with respect to NALSA to be able to develop something like that. That is basically it.
Again, as you know, I'm a lawyer, and many of you are my colleagues, lawyers, and we should know our role as a defense lawyer, as a lawyer helping prisoners, and I think it is very important for a lawyer committed to the cause of prisoner if he is interacting, and he should be sensitive towards his client. And I think that is a session, and this is really passionate to me, and I wanted to talk to you. One of the things before I start my presentation is covering the role of lawyer. When I visited jail, and Mr. Raghavan has talked about some 600 person in jail who granted bail already and could not come out, I got to know 325 persons in Delhi already granted bail, unable to come out because they don't have local security, unable to furnish bail bonds. I didn't realize what to do. With a lot of pain, I took decision to file a PI on my name, and then Honorable High Court framed detailed guidelines, and which is really good, and we are trying that can be implemented in other part of this country, wherein by virtue of that guidelines, now you don't have to move an application for reduction, you don't have to move anything. The courts have been directed to take suo motu, cognizance after the bail order is passed, 10 days or 15 days, see the execution of what has happened, why the person is not released. And the judges has been burdened. Yes, they are cursing me, but the impact is 295 have been released so far. 295 is really a success story, and that is because we realize, we as a lawyer have found that this is really imperative for us to raise these issues. So what are our roles? As a legal defender, understanding our roles, rights and obligations will help us more easily maneuver within the system and to excel our profession and to more effectively represent our clients, especially those in jail. What are the sources of these roles and obligations coming from Indian law, obligations under Indian law, rights, and then how do we apply to those to our clients? This is one of the modules we prepared for our lawyers. It's an IDJ website, it's available. You can download it. The source and rights and obligations are under international standards and Indian laws. What are the international standards? UN Basic Principle or Role of Lawyers talks about the obligation for the government through its authority to inform person who is arrested in detention or charged with criminal offence of his right to be assisted by lawyers of his own choice. Principle 7 says that an arrested or detained person shall be granted prompt access to a lawyer, 24-hour post-arrest maximum. And then, this I find is very important, Principle 9, education and training for lawyers shall be provided by the government. Because we need to be updated, we need to be skilled properly to represent, because if we are not effectively good in our practice, if we are representing people who are poor, that will be injustice to them. Principle 16, right to perform professional function without improper inference. 17 talks about lawyers shall be protected by the authorities when insecurity is threatened as a result of functions. Sometimes it will happen that if you have taken a case, controversial case or some case sensitive against the government, sometimes lawyers are threatened. And I think this is the authorities, this is the mandate international standard that lawyers should be protected. Then right to appear for your client. Whosoever is your client, you have the right to appear before the court of law. Civil and penal immunity for relevant statement made in good faith, in written or oral pleading or professional appearance before court. And the last is confidential communication with clients. These are the international standards, and then what are the Indian laws? Indian, Constitution of India, Article 22, right to consult and to be defended by a legal practitioner of choice of the arrestee as soon as possible. 39A, as you know, the legal aid, state shall ensure equal justice and free legal aid. Then under CRPC, right of an accused to be defended by a counsel of his own choice, section 303. Section 304 talks about the accused cannot afford a lawyer, then the state shall provide a state legal aid lawyer. Then we have a Legal Service Authorities Act, and then we have an Advocate Act. Those who are represented by a private lawyer, they are governed, those lawyers are governed by the Advocates Act. And besides the legal aid lawyers who are also governed by the Legal Service Authorities terms and conditions. In Khatri, state of Bihar, the Honorable Apex Court said legal aid shall be provided from the point of arrest, the point of first production of a lawyer. Now that subsequently, as Balkar Saab also made it mandatory. Who can be a legal aid lawyer? Who can be a legal aid lawyer? The accused cannot defend himself, he has to hire a lawyer. Legal aid panel advocates are under supervision of the Legal Service Authorities and are expected to take up cases where the accused cannot afford a lawyer. So I am briefly talking about some of the legal aid, many of the legal aid lawyers here. They have a responsibility. What are the terms and governing them? You may be knowing it, but I think it's better to repeat it for the purpose of your own sake. Supreme Court Legal Service Committee has a panel of lawyers. High Court Committee has a panel of lawyers, district and Tamil. Then, what are our roles at the various stages? Our role at the time of arrest, during investigation, plea bargaining, and trial hearing. We should know those limitations as well. The defense lawyer is entitled to interact with his client while he is in police custody, though not throughout the entire duration of the interrogation. That is very clear. It was mentioned in DK Basu. Subsequently, CRPC 41D of CRPC amendment has come. The right to claim the enforcement of client's right to know the ground of arrest. Section 20 CRPC and Article 22 of 1 of the Constitution. Then the police officer shall ensure transparency and accountability of arrest memo, which we talked earlier, is generated from the judgment of DK Basu. Police shall immediately inform the nearest legal aid committee about the arrest of an accused seeking legal aid. So this is Sheila Barse in 83, and still you will find that many of the places it's not happening. During the investigation and pre-trial stage, after filing the charge sheet before the court, the right to get a copy of the police report, FIR, statement of witness, confession and statement recorded in the 164, means of recovery of object or any other document filed along with the charge sheet, which the report under the 173. So that's a 207 compliance. I think many of the trial court lawyers knows it, that it is a right and role that you have entitled to take it from. Free access to your client if he is detained in judicial custody. So somebody told me earlier that there was a weekly visit in Tihar. Mind, you have every right to even have a visit every day because you have to consult, and this Honorable High Court has taken serious note of it, and they are now allowing it every day, except the holiday. Right to prepare effective defense and to do as many as research. Obviously, we are all lawyers. Whatever case comes to us, we should be putting our 100%, even if required research, we should do that research. That's our important goal. Otherwise, how will we effectively able to represent that person? Plea bargaining, I've seen many of the jails are having now law students guiding them, and the jail courts are there. But these persons are not informed what is the impact of accepting plea bargaining, or if there is a Kabuli, what you said, court, where the person said, "Jaldi bahar nikalna hai, to aap apni saza maan lena, theek hai, aapko chhod denge." The impact is whether he can be convicted, he cannot get a government job because this conviction can create a stigma on his life, and there will be a record. In the trial proceedings, I think many of the trial lawyers are here, and I think this is very important that we should know what are the intervention, because if we have to effectively represent somebody in trial, we should know. We should be warrior in the trial court. During the trial hearing, right to apply before the trial court to summon witnesses to appear in court and give testimony. So, if you have a defense witness, you can apply for that to summon that. Right to appeal against an order declining a request to summoning defense witnesses. Right to equal treatment to be given to evidence of prosecution and defense. So that you know that the prosecution evidence is there, but then the defense witness has to be treated equally. Then, right to be present when the evidence are taken at the course of trial. I think that is important. Whatever trial is happening, the lawyer's role is that he should be present. Cross-examination, right to challenge every questionable assertions. And then obligation, there are certain obligations, brothers. ancestral, because we find that many of the lawyers, for the sake of helping clients, sometimes do something which is not expected from the lawyer, not to temper the evidence, not to influence the witness, not to interfere with the investigation and indulge in corrupt practices. We have Bar Council of India rules to uphold the interest of the client, no withdrawal from the case unless for a good reason and with sufficient notice to the client. No suppression of material law evidence, the professional fee shall not depend on the success of the matter. And there are certain other Bar Council of India rules. I am skipping this. And Advocate Acts, we have a disciplinary committee. The clients in jail, if you are many of the visits, some of my colleagues, Sugandha, Raja and Delhi and other states, they will say that there are most of the times complaints, they talk that there is a corruption, a legal lawyer has taken money and is not filed my case and there is involvement. So, if those who are legally required, they know their role and responsibilities sincerely, so please do not indulge in any of the practices which is prohibited by the appointments. Then, Legal Aid Central Committee, I was skipping this. So the legal aid authorities have mandated certain roles and responsibility of lawyers, that they should organize the legal awareness. When you are visiting in jail, you should organize an awareness event also. You should identify the inmates who has been convicted, who are required to be filing appeal, and then take assistance of paralegal lawyers and interact them and advise them against. Do not deny them filing of any application unless there is a frivolous and false application. So these are the certain things which I wanted to discuss with you. But one important thing is, when you started your career, you took a oath, in fact for yourself, that you will be representing anybody. But you will be feeling so happy if somebody is in jail and represented by you gets acquittal and is connected with his family. Those prayers, you are changing someone's life, and that really is really appreciable. And please don't forget that prayers really helps. So please know your role, effectively represent your client, and take whatever remedy you would like to take in accordance with law. Thank you.
So, while the trial is going on and when the investigation report is submitted by the police, when they collect evidence or when they examine witness, they only give the things that they want to. And there is nothing in law that specifies that they have to give all evidence that they have come across in the case, or they have to give all, or they have to put all records that they have come across during the investigation process. So, I just want to know about that. Whether is there any law that exists which says that you have to show everything that you have come across during the investigation? So that is an excellent question. Who's number two?
I would like to ask with regard to one proposition. Our constitution says that the accused has every right to appoint the lawyer of his choice. If in case a person is a very poor and he does not want to appoint any legal aid lawyer, and what is the provision if he appoints some lawyer who is having a name, and what legal aid does reversify that lawyer? Any substance? Do you have any note with regard to this? Thank you.
Who's number three?
So, it was telling that for us, there is an extreme necessity is required. So, can you explain something about the extreme necessity for us, so that the lawyers will understand in what ground they can take the bail?
Four. You have five, I think. Who's four?
5 is at the back.
Four, okay. Go ahead.
Go ahead, please.
Go ahead.
Sir, I didn't have a question, I rather had a comment. We are anyway going to have a separate session on the role of law students in the legal aid system. But then, as Raghavan sir mentioned, that in Maharashtra we did a sort of a small scale experiment of this thing, that students assisted in the bail application drafting process. So I just wanted to implant this seed in the mind of everyone for the future session as well, that just like the medical students have a compulsory 6-month rural internship where they go and they help the patients. So can we have some kind of a similar process for law students as well?
To work in the legal aid for free.
Yes, yes. A compulsory thing, sir. Not an optional thing as it exists as of now.
And particularly in the rural areas too.
A small come experience, like we are discussing that legal aid courts are there, legal aid lawyers are not that efficient, or they are not being paid much. So this is somehow affecting the need of the people who are there. There are some organizations who are willing to work for you. There are lawyers who are educated from higher, from good institutes. But the system of granting access is somehow so much complicated. I mean, I have spoken to the DG of prisons, we have spoken to State Legal Service Authority Secretary, we have even written to many authorities, but still we are not finding a proper way by which we can secure that access. So this need to be discussed. There are lawyers to come out if the system is quite transparent.
So we'll take you as well. You've not spoken so far, please.
So along the lines of what?
Take the mic, take the mic. This is being recorded, take the mic. Yeah, take the mic.
So along the lines of what Achinkya mentioned in terms of involvement of students, law students in legal aid clinics and legal service authority, I would like to add that so this thing has already been initiated in some of the national law universities. It was a project in NLU Jodhpur and also NUJS Kolkata. But I think it may be even more, it may have better results if students from local colleges and universities would be involved. Because first of all, they are from the local, they understand the regional language, they understand the issues better, and they're also bound to stay put in the same region for a longer duration and to invest more in the longer term. This is the comment adding on to what I think.
And there's one more, I think. Yes.
So section 41 in CRPC involving some conditions for a police officer to make an arrest, one of which is reasonable suspicion. Now I think this is the legal concept which leads to a lot of unnecessary arrests because there is no really any contouring or defined interpretation as such as to what is the extent and boundary of your suspicion, which I think is leading to a lot of unnecessary arrest and detention. I think I might need your interpretation of this.
Now, this is a very interesting point there, because in American law, a phrase like reasonable suspicion would be quashed in a criminal statute. It would be quashed as vague and overbroad. Nowhere is suspicion or the grounds for suspicion set out. Very interesting question. So we've got a lot of interesting questions. We'll give everybody 3 minutes each, please.
Coming to the question which you raised, I think about the report 173. See, my basic first fundamental rule is what is the case of the prosecution? They are submitting report, and that is the responsibility of the magistrate that 207 compliance is made. Each and every page of that final report, along with the annexures, nowadays it is in the stats form, has to be given. What you are saying that during the investigation, if he has not filed anything in the charge sheet, right? I think that's what you comment. First, you know that you have a right to get all the documents. Second, as a defense counsel, when you are having the chance to cross-examine witness, that time you can always take out that from that person. If he has done any investigation on that area, something related to your defense, that's the opportunity. Otherwise, whatever the allegation, whatever the case of the prosecution on your client, they are bound to share with you. Right? accept certain exception, which is like in sensitive cases of rape. Some nowadays they are just not giving the copies, like suppose videography or something. They are showing in the court only. That's the situation. Second, one of the colleague is asked about the appointment of a lawyer of his own choice. There is no mandatory requirement that the court has to appoint any legal employer, number one. Number two, court also has a list of amicus curiae, which they appoint in the various states. They have formulated a list of amicus curiae of the respective courts with the experiences they are making this. However, the court can also, at the instance of the accused, can request that particular lawyer, but then it depends upon the lawyer to accept that appointment or not. Right? In a recent case in Delhi High Court, a person in fact sought not only a senior counsel but also sought that the entire record should be translated in Hindi. That was 10,000 pages of English documents, and everything was done, and his lawyer was granted by the court, and the legal authorities paid the bill of that. That is possible judicial intervention. I think extreme arrest cases, my colleague Mr. Vijay will talk about. However, the person, if he is likely to commit offence, he is likely to, it's a threat, flight risk, immediately suspicion, and those parts, suspicion part, why the judges are sitting. If you see that the remand order against Kumar's judgment is very clear, there can be a disciplinary action against the magistrate if he has granted remand without even seeing that whether there is arrest correctly made or not. In many cases, nowadays, in the Delhi High Court has recently passed a guideline also in 41A cases where the police officer is calling for arrest for investigation, and there has to be proper documentation, because earlier they used to call on phone or something like that. You come and then 2-3 days there is no record. So the magistrate are duty bound to check whether this police remand is necessary or justified, or arrest is necessary. Then only they can do it. And I did not see any of the justifiable order from the last. If you talk about 3 years record, call it in the NEPIR, you will not find any justifiable. Simple format application nowadays is fine as application by the police officer, and the judge is not applying their mind, and they are passing their numbers. And I think possibly you will find it.
Thank you. I'll just respond to one or two of the points. One is this whole issue of this, how do you define extreme necessity for arrest? And similarly, the related question of what is reasonable, reasonable suspicion. Actually, these have been vaguely defined, I think, with a deliberate reason. Because I think there was a lot of opposition when the government was coming out with this amendment, and the police departments across the country had raised a lot of questions about that. You should not curtail our right to arrest. So I think the words have been introduced deliberately so that the practice of arrest can continue the way it is being continued. In fact, ideally speaking, it should have been that whenever an arrest is to be made in such cases, the police should give reasons in writing. That's how it should have been put down. But it has been put down in such a manner that it matters. In fact, Bombay Police Act Section 122 says if anybody is likely to commit an offence in the opinion of the police, then he can be arrested. So you can have Section 41, but police can use other sections of the law. So this is really the travesty of justice that we all see around us. The question about not being allowed to come inside, I completely agree with you. There has been a culture of continuous attempts by the prison administrations and departments to not allow civil society organizations to come in, and this trend has got increasingly strengthened with the more and more appointments of IPS officers in the police departments, because their whole attitude is largely very prosecution oriented. And one more point I want to add here is the MHA advisory which was issued in 2016. After this BBC documentary on this this Nirbhaya case, offenders were interviewed, and that has created more problems now. Many of the state DGPs are refusing permission to even students, researchers, forget interventionists and lawyers, to come inside on the ground that MHA advisory exists. And this is actually something that needs to be challenged in the Supreme Court. Because how can you issue an advisory? For those of you who don't know, there is an MHA, Ministry of Home Affairs advisory issued to all the home departments and DG prisons saying that anybody ordinarily don't allow anybody inside. It was issued in 2016. And then it says that you can allow if you think it will be for the benefit of the prison department. And then it goes on to say that the prison superintendent can ask for a security deposit of 1 lakh, which can be forfeited if they. So the entire advisory is drafted in a manner to ensure that people don't get access.
Another interesting thing about the advisory also is that it says you're not allowed to take pen and paper inside. Really funny.
I mean, it's anti-constitutional.
Inside
the jail, when a person proposes or as a visitor.
So again, a couple of things, and I think most of it has been addressed by Jindal. But with respect to the reasonability of arrest, and so there are two things. One is credible information. I mean, it is credible information that the person who is being arrested has committed the offence, and then or there is reasonable suspicion. And yes, they are vague, and that's a problem. And as Dr. Ravan said, that it is also required in certain cases. At the same time, I also believe that if it's challenged enough, especially enough, one can crystallize it into in what kind of cases this is reasonable and this is credible. That's something that the onus is on us as lawyers to be able to question that regularly and ask magistrates in which case it is reasonable. That's something. The other thing, and that's something that I've been hearing since morning and talking here about the remuneration of legal advice and quality. Certainly, it's an important aspect. But one thing which I also believe is being missed is A, monitoring and B, mentoring. Now, the NAS due to the mechanism with respect to how to monitor legal advice, but that doesn't really happen. And in some states it does happen, but in the majority of the states, the monitoring mechanism is not followed, and that has an impact. The other is mentoring, and we try to do that in some of our trainings with legal advice in Pakistan, where senior lawyers should be available to help and strategize with lawyers to be able to how to go about this. That would be another recommendation.
Gaurav Agrawal, who has done the work as a micus in the Supreme Court in the prisoner's rights case. It is actually quite a unique development, because generally we get individual orders of the Supreme Court from time to time, and we are happy that we get some Supreme Court order in favor of prisoners. But this is unique because over the last, I think, 1 year, if not more, the amicus appointed in the court has presented to the court a range of issues, which he'll talk to you about now. And not only has he presented these issues with a great deal of study and preparation and so on, which the court appreciates, but the judges in the court, the bench headed by Justice Lokul, have been very appreciative of the work done by the amicus and with the civil society organizations supporting it. And he will introduce you to some of these orders in case you've not seen them. But it might be a good idea to get out all the judgments, because one after the other, and I suspect in the next few months as well, there are going to be a spate of judgments from the Supreme Court on business rights. What is the importance for you? Because you can take every one of those judgments and go to your High Court and say, this is the judgment of the Supreme Court. This is the fact situation in my state. The judgment is not being implemented, therefore implement. And as you know, when a High Court judge looks at the Supreme Court order filed in a PIL in the High Court, you can imagine that judge will normally, almost always, try and implement that order in the state. One of the purposes that we are doing this meeting, one of the purposes is so that you can understand what has happened in the Supreme Court. You will meet with the amicus after that if you get a chance to, you can meet with them. You can sort of look at some of the orders, and I think we've sent you all these on email, but we will send it to you in case it's not there. And then you can take up a series of cases in the high courts. So the idea is to promote litigation on prisoners' rights in the high court by using all these orders of justice locally passed in that prisoner's case.
So, as I said, I will try to finish. There's a large number of things to cover, but I will just cover a few things. Recently, you must have, if you happen to follow Vijay Mallya's case, one of the grounds in which he is resisting extradition from UK to India is that I would be lodged in an Indian jail in India, and the conditions of Indian jails, by and large or largely, is not something which is commensurate with what is expected of a jail as such in light of human rights perspective, and therefore I should not be deported from UK to India. This is one of the reasons which he has actually given, one of the many reasons which he has given to oppose being extradited to India. So, for the fact of the matter remains that though there has been a large number of improvements in a lot of jails in the country, whatever little I have visited in the last 3 years, some of the jails, or if not all, remain to suffer from some of the various deficiencies, if I may say so. So what happened in Supreme Court was that Justice Lahoti, R.C. Lahoti, former Chief Justice of India, wrote a letter sometime in 2013 to the Supreme Court, saying that, well, there are a large number of problems being faced by Indian jails, amongst them being overcrowding, shortage of staff, lack of training, etc. And the Supreme Court needs to address these issues in a PIL. Based on that, a PIL was registered suo motu by the Supreme Court. So one of those examples of an epistolary jurisdiction, what we call when a letter of petition is treated as a PIL. And it was registered as Writ Petition Civil 406 of 2013. And notices usually went to all the states. Then a very fantastic development, I would believe, was that during the tenure of my Lord Justice Dattu's time, a social justice bench got constituted in Supreme Court for the first time. So that's again something which you may be aware of or you should be knowing of, that a bench of Justice Lopur was constituted which will take care of these PILs. And that's how I came in the picture as a amicus, and large number of issues came up as regards prisons. So 3 or 4 issues I will flag. One was that the states provided the data to the court which showed that a large number of jails in the state were overcrowded. Overcrowded meant that if a jail had a capacity to entertain 100 prisoners at one time, some of the jails were having 150, 200 or as high as 600 people. So in a case like Arthur Road, for example, in Bombay had 4 times the number of people who were there. Now what is the effect? I mean, it's very easy to say what's wrong if more than twice the number of people who are sitting here occupy the room. Now everybody feels uncomfortable. So it's not as if only 100 feel uncomfortable, 200 feel uncomfortable. Now take a situation where suddenly this room has 400 people as against 100, what is the capacity? So you can imagine the human rights violations of those people because they don't even get space to breathe. So in Arthur Road, in fact, you have people taking turns to sleep. So that's the situation as far as some of the jails is concerned. Number 2, the issue was of staff. So staff requirement in India, there is about 74,000 people who are required to man all the jails. Now those 74,000 people are meant for 100 prisoners. On one occasion, you had 200 people occupying 100 people's strength, and the staff was half of what was required to actually cater to 100. Because the jail staff caters to all the needs of the prisoners, right from the eating to the transit, to medical, everything is catered because the person is fully inside the jail. So that was the second aspect of the matter. Third was, of course, that legal aid was being, is being something which is very deficient, and we are not having enough lawyers going there. So that aspect I will not address because I assume you have separate issues. So when this petition was taken up, third was, last one was, and since I'm just doing the whole thing, last one was deaths in jails, and you would see a large number of deaths in jails. Recently, Baikala incident where there was a death in women's jail for something where people were lynched. They were tortured by the personnel, the jail personnel, or even tortured by inmates who are inmates. So those aspects was the total area which was being covered by the PIL. Now, as far as directions are concerned, you would find them all on the Supreme Court website when you click daily orders on 406 of 2013. My purpose is not to tell you each of every direction, it is not possible. But what's possible is to tell you what are some of the substantive orders which you can take advantage of, as Collins sir has said, while you practice and while you grow and while you are aware of. So first thing is about deaths in jail. I mean, that is something which really upsets a person, is that a person who is a normal human being and not death due to old age. Please don't misunderstand me. Everybody has to die one day. There are normal deaths also, but a death in a jail really shocks the conscience of a person, because we place that human being in custody of the state, and for whatever he has done, he has to undergo the sentence. He may be released in future, he may not be released in future depending upon the nature of sentence. But while he is inside, the state, its officers have to take care of him. Least of all, he should not be in a position where he ultimately loses his life. So, natural deaths apart, if there are unnatural deaths in a jail, which may be due to inter alia, lack of proper medical care, which is also an unnatural death. 2, maybe one inmate has attacked the other inmate. Or 3, and the gravest of them all is there is a death at the instance of the jail staff. Then there is an entitlement to be paid compensation for such deaths. So that is something which, of course, is understood, that if there is a violation of the human rights of the prisoner inside, one is entitled to death. But what is the development in this judgment is, each High Court has been directed to institute a suo motu PIL and take cognizance of all the deaths which have taken place from 2012 onwards and which take place in the future, whereby one need not have to wait for a person to approach a court. So if any of your clients or any of your persons come across, any of your persons approach you saying that, look here, there has been a death in the jail and we believe that this death is not a natural death, then the best case scenario for you will be to approach the High Court in these suo motu PILs, bring it to the notice of the High Court, get an inquiry conducted, and get compensation from High Court. So that is something which is a very, very positive step by the Supreme Court, by a judicial order, conferring upon the High Court straightaway jurisdiction to address human right violations in jails, which result in unfortunate and unnatural death of an inmate. So that is the first takeaway from this. I mean, there are a large number of takeaways, but I am just addressing a few. Second is the constitution of UTRC. Now, your UTRC is an under trial review committee. You will have this session tomorrow with Sugandha. She has been helping me out with Ritu from, you must have known Ritu from HRLN helping me out. Under trial review committees was a very big development by way of a judicial order from the court. Now, UTRC is basically actually a body which was advised by Ministry of Home Affairs, but it was not functioning in all the districts. So the Supreme Court in 2015 directed that each district will have an under trial review committee headed by a district judge, and will have various other members including the SP and the legal secretary DLSA. how could you contribute to the functioning of UTRC? So now in a litigation sense, since I'm addressing law, in a litigation sense, you apply, you see an under trial, he has been granted bail, as I said in the previous session, he has not been released on bail, right? Now, how could you help him? The UTRC was meant to help exactly those kind of people who are not able to be released because of some systemic failures in our system. So if a person is very, very resourceful, he is able to get out on bail the next day after the order. But if a person is not resourceful, he is not able to get out. He remains inside for days, weeks, or perhaps months. He is not resourceful, so he doesn't approach a lawyer. Maybe the legal aid committee is not able to help him. So the court devised a system where the UTRC will suo motu again. So this is a very second important thing. Is a mandated duty on each of the under trial review committees to examine the cases of under trials to see if they deserve bail but have not been released, or if they have been granted bail but they are kept inside for reasons which can be addressed, which have not been addressed so far. More of this UTRC is tomorrow, so I'll skip this and move to the next one. The third important development which Supreme Court is still working on is digitization and computerization of jails. Now, this helps in a large way in keeping up-to-date data available with various stakeholders, including lawyers, to know exactly when the accused has come in, which jail he is in, what offence is he charged with, when he can be approached, etc. So this thing is still a work in progress. It's being done through government agencies, but it's a slow work. But once if it is digitized, you should be able to access data for your clients to know exactly when he has come in, when can you meet him, when or how many times can you meet him. All the rules, etc., relating to your clients, with jail visits, etc., can be put on. The last thing which is there is, I don't know whether you have heard of open jails or not. So open jails are something again which Supreme Court has taken up in this PIL, and in fact has not directed but requested the states that you should set up open jails. Now, open jail is a very different concept from what we as students or as lawyers initially were used to, that a person would be inside the jail. One day when his sentence is over, he will be let out and that's the end of the story. Open jails is something in between a closed jail and full freedom. Different concepts of open jails exist in the country, but basically a person is able to get out during the day, go be with his family or go do his work if he wants to, and he can come back in the night and he is inside during the night time. So the Supreme Court is encouraging states to set up a large number of open jails, because open jails help in reintegration of the criminal or so-called convicted person with the society. So that's the other focus area in which a large number of work of the court is going on. The last work which will probably take off is from August is concentration of children who are in jail. Now it is a little shocking, but yes, if a woman who is arrested and who is a child who is less than 5 or 6 depending upon the jail rules, then the woman is entitled to take the child inside the jail with her. So there are a large number of jails which have small children in the jail with the woman in the jail. Now these children really need to be taken care of, because one, they are not going to schools which they are, or going to play schools which they are supposed to go. Their education, their interaction with the society, their growth and their stimulus is completely different. Secondly, and more importantly, there are children of parents. Parents are inside and the children are outside. So either one of the parents is inside, the other one is dead or not available, and that sole parent is found to have done something, he is locked up inside, and you have these 2, 3 small kids, boys, girls, etc., who are just outside, and we do not have an institutional mechanism as of now. In most states, we are still working on this, I'm taking Mr. Raghavan's help on this, and National Commission for Women has been asked to look into it. So the bottom line of all this is that through this PIL, Supreme Court has realized that merely locking up a person inside, be it for a suspected crime or after his conviction, doesn't mean that the problems end. In fact, some problems begin there. Some of them may be related to deaths, some relate to medical treatment, some relate to children, some relate to children who are outside. So these are issues which are being addressed by Supreme Court in a it's a very slow process because there are a large number of stakeholders. It's not as if you get up one day in the morning and say, okay, I will just wish this were true and pass an order, it will happen. It doesn't happen that way. So constitutionally, jails are a state subject. So everything you do, we must take into account their financial process, their availability of resources, and slowly try to give them some directions to follow and improve the conditions of the prisoners in the respective jails. So this is the body of work which Supreme Court has done. There are a large number of orders, I said, which are available on the net, but these are some of the things which you should know about the work and ongoing work. And if you can contribute, you can do the same way for your respective jail or jails, be it in a sub-jail, be it a district jail. If you believe that the conditions in your district jail are appalling, which are heard from your clients or through legal aid channels, you can take up an issue like there's something missing in a district jail you wish you had, which will improve the condition of the jail. You can take it up and approach the High Court saying that, look here, Supreme Court is doing this on a larger scale. On a smaller scale, a particular district jail or a particular sub-jail doesn't have these facilities. Why would you direct the government to provide these facilities to the prisoners? So I think that's the contribution which each individual of us as we grow in our profession can make. So that's as far as my presentation is concerned, sir. If until unless you want me to, I can go on, but I think that's about it. Yeah. Yeah. So the purpose was simply this, that Supreme Court is conscious of the fact that all is not well with jails. You should contribute in whatever small manner possible. Now, I leave it to you to ask me any questions relating to this broad framework of areas which I have covered. I have worked on these for the last couple of years, so with little degree of, I may know about some questions. Yeah, so can I start from the back and come forward? Is that okay? So, yeah, please.
Two very disturbing issues in my mind.
Yes.
One is 436A that in case of 436A,
yeah,
offences punishable with death are not applicable.
Correct.
But after sentencing judgment, so and so, we know that there is an exception.
Yeah.
So can the courts look into it a little differently? That is the first part.
Okay.
The second part, sir,
yeah,
is that under trial prisoners are not getting remission. If the period of remission were to be calculated, then we would have a lot of unnecessary detention would definitely go down.
Yes, correct.
Can you kindly enlighten me on these legal aspects?
Correct. So I have noted down the question. I just take all the questions just in case it's hard. I can answer 3 or 4 at the same time. That's okay, sir. So yeah, sorry. Anybody in the last row? No, second last year. Yeah.
Good evening, sir. Myself Ashish. I am an academician by profession working with University of Petroleum and Energy Studies. Sir, my question is relating to the human rights. In the area of human rights, we have traveled a long journey from A.K. Gopalan to recent NASA judgment. But with specific reference to the prisoner's right, what is the current status in the Supreme Court with respect to the right to conjugal visitation, right to conjugal visits? With respect to certain high courts, recently Tamil Nadu High Court has allowed the right to conjugal visit, and in 2015, in a judgment by Justice Suryakant from the Punjab and Haryana High Court, have allowed it.
Okay.
So, what is the status in the Supreme Court?
I will address. Yeah. Yeah, please. Sorry.
Hello, sir. I come from Chhattisgarh.
Yeah.
Regarding this custodial death cases,
yes.
At the personal level, I have filed several custodial death cases in high courts, maybe about 7 or 8. But the problem lies in the fact that there are cases which I have filed in the year 2010, 11, 12, but these cases have not come for final hearing. So, can we get some order from the Supreme Court that the High Court should expedite these cases?
Yeah. Okay. Yeah. So anybody in the third last row? Yeah. Yes, ma'am.
So I am a human rights student,
Yeah.
and the last conference that I attended in Gujarat National Law University. So where I felt that there is a wide gap between the academicians and the practice. As in, we only talk about lawyers, but what about the social scientists, criminologists? Like if they work with the police, then we can have a better criminal justice system. So what's your views on that?
Yeah. Yeah, sure. Yeah.
So my question is regarding the funds that the police stations have.
Yeah.
So do you think there is a shortage of funds that if even if there are funds, are they being allocated properly?
Okay.
Or is there a corruption and then these institutions end up without any money in the first place, and that's the reason why we don't have so many facilities in the police stations. One more thing I wanted to ask, it might be a bit going away from the topic, but even overpopulation is one of the reasons why we have so much of crowd in the police station. So do you think the country should adopt something like a two-child policy like for China or something?
Okay, I understand. Anybody else? Yeah.
My knowledge, this case is still pending in the Supreme Court. And it was directed that all respective high courts of all the states will also take up this matter as no. I've been trying to Google and find out from the journals if any of the high court has taken up the matter and what has been the progress.
Okay, I'll update you. I'll update you about the progress.
Sir, excuse me.
Yeah. Sure. Yeah.
Sir, does the Supreme Court have raised any concern over the aged prisoners in this case? Aged prisoners on their release?
Very good question.
Yes, sir.
Okay, so I'll stop here for now and I'll come back to you because I can't remember all this at the end of the day. Okay, so quickly now I'll attempt to answer this. As far as 436A, it doesn't apply to death or life sentence, right? But as far as the under trial review committee is concerned, we suggested to the Supreme Court that there should be a monitoring mechanism to see that the cases are tried quickly. That's the purpose of these under trial review committees. But unfortunately, we couldn't make much progress on it. So it's a work in progress again for monitoring of all cases. I mean, all under trials. We have a large number, 66% under trials, because the cases are not getting taken up. So all of these problems have arisen because we are not able to decide cases quickly now. That problem will remain for life and death sentence cases as of now. No solution is in sight as far as this matter is concerned. I have no idea about anything else. As far as remission is concerned, your question was, you are absolutely right, under trial prisoners, during the time they are under trials, do not get remission for the period even after they are convicted. So there are 4 years or 5 years which they spent as an under trial, so as to call goes waste. Again, that's a legislative change which will have to be incorporated. It's something which we can't really help because remission itself is something which the state has to address. Number 3 is, as far as conjugal rights are concerned, it's something which is completely out of the present framework. There is no provision to my knowledge in any jail, any legalistic way where you can enforce that there is a conjugal right. But yes, open jails is an excellent concept of indirectly enforcing what you believe would be a right to conjugal. In fact, broader than conjugal is family relations. So therefore, we will have to work more on that. Yeah, you had something to say here.
I was not saying we have to enforce conjugal rights.
Yeah.
What we have to, where the party is willing and
He or she wants to have sexual relation with their legitimate spouse, then in that case it is also part of the human rights, sir.
Yes, but as of now it is not something.
Yes, sir, there are no guidelines, no legal framework.
Yeah, but it's something which we can really think of in terms of open jails. If you have open jails for even under trials or even non-serious criminal convicts, is something which really helps because it is, as I said, it's larger family relations. I mean, a child should also be able to say, I want to see my father. Why should he be not permitted to do so? Yes,
it's again a very good ground for parole, as Mr. Gupta says. So that's number 3. Number 4, about custodial debts. See, now custodial debts are 2. One is a police station thing, which can be also called as a custodial debt. I have not done any work for those debts. As far as debts in jails are concerned, all the high courts, and that's answer to ma'am's question as well. Supreme Court directed 2 separate PIs, one for the custodial debts in jail. Now from 2012 to 2017, all debts will have to be suo motu inquired by the High Court. Each of these High Courts, to best of my knowledge, have instituted a PIL for custodial debts. And in Bangalore, one of my friends himself is a amicus curiae, so he keeps being in touch with me as to what is the procedure the High Court should adopt. What is the compensation which, these are all grey areas. It's very easy to say, okay, death has taken place, you must compensate. But these faces a large number of challenges. Who should investigate that and who should come to the conclusion? Because these are all factual controversies. How much time is the High Court willing to spend? It's not a trial which is going on as to the death. So, and it may have an effect where in a criminal case, is lodged and that comes to the conclusion that there's an acquittal in the criminal case. So there's a complication, but yes, if the death in jail is there, then you can apply in view of the judgment here before the Chhattisgarh High Court. So ma'am, answering your question, as far as custodial debts is concerned, that PIL has been registered in all the High Courts. Now, each number I am not aware of, but you can definitely ask. Recently, Supreme Court has directed a fresh suo motu petition for overcrowding and also for staff vacancies. So that is something which I should share with you, Mr. Raghwan, also. You can probably help the Bombay High Court in reducing the overcrowding, especially in Arthur Road jail where it has been. So I think that is something which the Supreme Court realized that they can't monitor all the 1400 jails in the country at a national level. So they directed all the High Courts to institute suo motu petitions to address the issue of overcrowding and for staff strength. So this is an easier PIL because it's the court and the government, and probably your organization or you can assist the court there. Now, as far as academics and the people who are social scientists, etc., being involved, as today is, I just happened to meet the Delhi fire officer for some completely unrelated work. He was telling me that he is working with 40% staff. In the whole of summer, he was literally awake 20 hours a day because summers in Delhi. Yeah, anything can happen anywhere. He said he was working with 40% of the staff. So everybody's stretched. I'm not sure why the government is not filling up judicial vacancies or vacancies in jails or vacancies in police. So I doubt that there will be any more posts for sociologists, etc. But I wish there were. Leaving it there, I will take to the next station, that is a funds issue which you raised. So funds is a very, very big problem when I have done the work for jail. So there is a huge disparity, and you will find in one of the orders of the Supreme Court also. There is a calculation made by the National Crime Records Bureau as to the amount of money spent by a state per year on a prisoner. Okay? So how much is the money which the state government is spending on a prisoner? It was found to be as low as ₹3,000. So you can imagine that for 3,000 rupees is the total amount of food or medicines, etc. on an average is being made available to a prisoner. So that's where we are, because jail's budgets are per month, 3,000 rupees per month, sorry, not per year, 3,000 rupees per month. So that's the level at which it basically comes to literally 30, 40 rupees or 300 rupees a day, in which you have to cater for all the food which he is supposed to take care, the medicines if required, everything, security, everything. So if you have a total budget of the jail divided by the total prisoners, you will come to this figure of 3,000. So funds is a big issue. Of course, things would have been different, but I think it requires more than funds. It requires something which we need to invest in human resources, not simple infrastructure. So you need to invest in rehabilitation officers, you need to invest in medical officers. All this is not happening. Now, as far as aged prisoners are concerned, I tell you my personal experience. I went to Gurgaon jail, and there was an 80-year-old man who couldn't literally move. And in fact, his son used to stay with him 8 hours or 9 hours a day with the permission of the DG, because he can't be let out, the prisoner can't be let out, and invariably other prisoners have to take care, and they can't take care of that gentleman at all. So it's a huge issue which needs to be addressed. I guess if you can take up some research and come up with cases of how many people are injured, more importantly, who are suffering from diseases which can't be cured and are in the the last years of their life, last months, so as to say, but are still inside. Yeah. I can't hear you, sorry.
I have done the research on Tamil Nadu through RTI.
Okay.
How many aged prisoners who crossed the age of 65 years?
Okay.
I got the result that 247 prisoners.
Okay.
And they are aged about 65 years to 85.
Yeah.
About. So I filed a PAL before the court of Madras High Court, and they issued an order within 4 months, consider their premature release.
Oh, excellent.
Based on that, the government also issued an GO.
Yes.
Then later, now they revoked that GO, and they never assigned any reason for the revocal.
Oh.
So, which is now a big problem, and I need to approach the court.
Yeah, that's great.
So I need to take this issue to the Supreme Court also, because the aged prisoners are not in their own.
Yeah.
Also, there are decrypted prisoners who cannot do any crime even when they are allowed to go on parole.
Right.
So, in such case, if the spending money on them is a waste of energy, and their life is destroyed, and everything is a problem.
Yeah, you're right. Absolutely. I agree with you fully. It's life with dignity is not there anymore.
Yes.
You're dependent on others who are not your own. And the people treat you not well in jails.
Yes.
Okay, fine. So I finished at row 3. So anybody from row 4? Okay, yeah, sorry, I missed you there.
Hello, sir. So we talked about how we can collect more data from the prisons and how we can probably analyze their data. Like as of now, also there are certain types of records that are being maintained by the prison authorities.
Yes.
However, there are certain more categories into which that data can be categorized. For example, we just said that probably sir had to file an RTI to get to know about how many old age people are there.
That's right.
And such data is not readily available as well.
Yes.
So, are there any channels except for litigation before the High Court or the Supreme Court? Because that, I suppose, can be time consuming. So, I just wanted to ask, are there any other channels where we can put up such a plea that you can go ahead with such types of categorizations as well? And then perhaps the authorities can maintain such records for academic purposes and other purposes as well.
Correct. I understand. Anybody from row 3? From bottom? Okay, yeah, okay. Sorry, we'll go back. No problem. I mean, I better have this way than giving a presentation. Yeah.
So, I'm Pranav. I'm a 4th year learner from St. Vincent Catholic University.
Okay.
So, we cannot always rely on the government to give us our rights. That's a given.
Yeah.
So, how about we empower the prisoners? Now, jail authorities are and have been working with the private players.
Mm-hmm.
So, how about we have long-term joint ventures with private players who skill the prisoners and then utilize their workforce and use that money to give them facilities like healthcare, recreational sources, quality legal aid. And once their sentence finishes, these convicts are now skilled and they can work by themselves and live a life in dignity.
Yeah. Okay, I understand. Okay. Somebody else was there. Yeah. Sorry.
You have mentioned the extradition case of Vijay Mallya.
Yeah.
There in Punjab, we are from Punjab. There in Punjab, there is one famous case, Jassi murder case. The girl called Jasbir Kaur and got honor killing in the year of 1998 and 1999.
Okay.
Then by the contract killers, because the parents of that girl are back there in Canada. So this trial is still going on because the accused are having that political influence in the government. Somehow, in a year and a half back, the government in Punjab changed, and there is a swiftness in the case, and they have forwarded to the Canada government the extradition application. And then what happened? The team from Punjab police went there and came back empty-handed on the same ground. So, is there a directed petition in the Supreme Court, one way other around, that the criminals are taking this ground, on this ground we can have a directed petition in the Supreme Court that all the directive judgments should be implemented?
Okay, understand. Yeah. Okay, so we are finally on the third row finally. Anybody? Yeah. Yes, ma'am, you had a question, ma'am. Anybody?
Hello, I am working in Kerala with prisoners. So one thing that I have noticed that has not been come into discussion yet is the migrant workers that are picked up. I'm not talking about Bangladeshi migrants, I'm talking about in-country migration. So in Kerala there are a lot of migrant workers from Bihar, Orissa and the northern states and northeastern states. The problem is when they are applying for bail, usually they are picked up for very minor offences, and when they are posting for bail, what happens is the court asks for documents, and most probably they do not have documents, or when they have, it's from outside the state, or that's one part altogether. Second is police do not even contact their family members who do not have an idea where they are. So that is another issue. So what is being done in this? Also, another thing is about women prisoners. Women under trial prisoners. One thing I have noticed is whenever I have an interaction with women under trial prisoners, first thing is, so I thought the condition was a little bad, but once I listen to other people, I understand it's more worse in other parts. It's not possible to have a conversation with them about what is happening. Most of the time, the conversation is led by the prison authorities itself. So, when during the legal aid clinics, when the lawyers are talking, most of the problems are set by the prison officials and not the women themselves. So, two issues.
I understand. This is a new thing for me. Okay, anyway, yeah. I have 4 questions. Any more? Just 1 second, man. Let me anybody here? Anybody? Yeah.
Good evening, sir. I'm Kobe Agrawal from JLC. So I have 2 questions, one with respect to custodial torture and the other one with respect to prison reforms. So firstly, so as we know, there has been legislative reforms in the field of custodial torture too. Like in 2010, when there was introduction of an anti-custodial torture bill, which, as per the law commission's recent uprising, also it was introduced in the parliament again. Yeah. And the interesting part about that is the definition of torture has been diluting since these many years, which poses a serious question of whether we are even serious about this issue at all. So as an advocate, I would like to know what is the stance of judiciary when it comes to legislature taking reforms on such issues. Secondly, covering the prison reform issue, there has been a recent debate that since prisons come under the state list in the constitution, converting it into concurrent lists will help them unify laws for all the states in the country, and which can be a step ahead in prison reforms with respect to adopting good practices from all the states. Yeah. So I would like to know what your opinion is.
Okay, so I'll answer these 5 and come back to you. So I'll answer these 5, otherwise I'll forget. So as far as data is concerned, answering your question is a very, very serious challenge for us. I mean, Ms. Sugandha, if she's here around tomorrow, she'll tell you how it has been such an issue getting data from state. And in fact, if you see the last order about order in August somewhere, Justice Lokur in fact directed that there should be a meeting of all DGs only on the issue of how do we maintain data as far as prisoners are concerned. What is required to be put in public domain, what is not required to be put in domain. And I participated in that meeting, and let me tell you, nobody wants to share data. And they have concerns, and they have good concerns, and for the time being, it's a problem which will remain for a very, very long time. There are privacy issues Some people don't want to their data up available in the public domain. So until unless you mandate by law that every person's data will be made official, you are entitled to your privacy, and therefore we run into a serious problem as far as getting data is concerned. So very little will be available in public domain because it's not an easy question for even policy makers, lawyers, or even court to answer. I hope you understand that. So whenever your research or academic research is there, it will be on some study conducted by state human rights organizations who by statute are mandated to actually visit jails and get data, be it NHRC, be it the Protection for Children, the Child Rights Convention, etc., be it the government themselves, parliamentary delegations who have gone into jails. So all this data in disjointed formats are used to actually put in a present situation. So I think that will remain a challenge for a long time. Secondly, as far as skill is concerned, I am very happy. That's what exactly I was telling you. That the only way forward is to put in human resources in jails. Be it vocational training, and Ajay is here. If you get to interact with him, you will know how much effort is he personally putting in setting up a jewelry unit in Tihar, if I am not mistaken, Ajay. So that's a great achievement, and I mean he has been asking me to come with him, and I have not been able to go. It's a great achievement to have a jewelry unit in Tihar jail to skill the people. In fact, he is working on placement of those women who have been trained. A large number of NGOs are associated, like Ms. Vedi's organization, India Vision Foundation. Ms. Vedi will be addressing you, I think, day after tomorrow. So she had done immense work. I think she won a Magsaysay award. Mr. Gupta is here again. You can interact with him. Tihar, you will find, has a whole industry to take care. You will see some of the products of Tihar jail later in the evening when you go out for dinner. So a lot of effort is there. I can't speak for the country, but yes, that's the way forward. I think skill development is required because we go on the basis that crime is something which a person was in the circumstances forced to do. Given a choice, he may not have done it, and there is a chance that if properly trained and rehabilitated, he will not repeat it and he will be a reformed individual. So the whole philosophy of jail administration is to change. It is changing a bit, and it will change where you keep the person saying that this person has committed a crime because of certain circumstances, he needs to be reformed, and our achievement would be that he goes back and leads a normal life. So that's something which we really need to think of. Now, as far as extradition is concerned,
my question was predicated further.
Yeah.
Not just attempting to skill the prisoner, but also using it as a method of revenue generation.
Sorry, I did finally. So they do work while they are inside, they earn money while inside, and when they get out, I think the money is given back to them. So while they are inside, they work for the skills which they may know of or they may develop while in jail. I can speak from Tihar experience at least. And it is all credited in a bank account for them, and the day they go out, they are given the money. Also, there are schemes where people are given some seed money. It's a very low amount, it's about 30,000 in a state like Haryana has a scheme where if a person wants, he goes out and he is able to get a loan from the government interest of 30 or 50,000 rupees to set up a small business, like a small shop or something like that. So yes, the skills are very helpful. The skill helpful if he works in the jail, he'll earn money and will help him when he goes out of jail. So that is important, I think. Yes, if it is there in all the jails, I think that person will be able to earn something.
Also, if those companies who are like willing to come and work with the prisoners,
yes,
if the burden could be shifted on them a bit as well to make the prison better rather than just on the government.
Okay.
Because ultimately they will be the workforce.
That's a good thought.
So, we give benefits to the employees, now they are your employees, so give them some benefits like that.
That's a good thought. Yeah. We'll have interaction with a lot of people over the next 2 days, so that can be discussed. So now extradition is concerned is a very, very touchy topic. It's a topic which is beyond today's purview. So I will not be able to address or answer that, sir. It's something which I'm really not in a position to address, so I'm really sorry about it. About migrant workers, ma'am, you raised a question. It's a larger issue about what you call local surety, which is an issue which Ajay addressed in the person is arrested for a very small thing, as much as small theft, and after a week or 10 days he says, okay, fine, now you can go furnish a bail bond, which he may be able to do, but he's not able to get a local surety, and he remains inside. Now, I think that's a very big challenge, especially if a person is from northeast, say Meghalaya, and he is detained in Kerala, because they will not be able to verify his address also, and he will not be able to get somebody who is willing to stand surety. I think that is something which, if you see the Delhi High Court judgment of 7th of March 2018, right? I think it's 8th March 2018 in his PIL. So if you Google Ajay Varma versus State of NCT of Delhi and 8th March 2018, the courts have now, in Delhi at least, have been burdened with the responsibility, if I may say so, to ensure that if you are granting bail to somebody, please ensure he or she is released. Don't just leave it to the jail authorities, etc., or the police to verify the address and verify the documents, etc. If it is not happening, please ensure it is getting done in this manner. In fact, in Delhi, there is a serious problem. We have at least one person I know of who is of Nepali birth, and he is detained of a small offence, and although he has been granted bail, but he is just inside because he has not been able to furnish the documents, and no court is willing to release him because he is from Nepal and there are no sureties, etc. available. So that's a real problem which we are facing. As far as women thing is concerned, I am really not aware of this other issue you mentioned. It's something which I guess on 2nd August, if I get an opportunity in the next hearing, I will take it up. As far as custodial torture is concerned, in fact, there is a separate PIL in Supreme Court which is seeking a direction to the government to pass a law, because we are signatories to the convention. So, I guess the government has made a commitment to the court. If you Google torture convention in Supreme Court, you will find that the Attorney General has made a statement that the government will be coming up with a bill. Now, if the convention definition of torture, and I am not aware of that's what he says correct, but let me assume that to be so, if the convention definition of torture and the national definition of torture are at variance, then there may be a problem. Unfortunately, we follow a system where international treaties are not directly incorporated into the Indian system. So the law will probably have to be challenged as and when passed, that it does not take care of all the forms of torture. So we will have to wait for that. On the last issue about prison reforms, what exactly was the question of prison reforms? Concurrent list. I think it's an impossible situation that putting deals between the concurrent list for two very good reasons. Large number of the politicians are inside, so they don't want the jails to go with the central government having any say, because then they won't be able to come up. Right now it's very easy. Whenever the government changes, you will see a spate of cases getting withdrawn of the previous government because they were in opposition and their workers or their relatives or etc. were inside, and then now the government has changed, so they find it easier at the state government level to do it. I think it doesn't work because I don't think so the central government will be in a position to monitor jails. From my limited experience of 2.5 years of this PIL and visiting jails, it's a very local issue. Like the central government doesn't have any police powers, right? All the police powers is with the state government. I think it will be impossible for the central government to monitor 1400 and administer 1400 jails. They don't have the necessary commitment to do so and the money or the manpower to do so. So I think that the best way is that we improve the system as it exists. So one or two more questions because 6:30 is my deadline. Sorry, yeah.
Actually, my main, since you are addressing all these issues on unnecessary detention and other how people can be released, and Supreme Court has listed out categories of people who can be released, but they themselves are saying that it's not being implemented. Even the under trial review committees, even when they pass orders on release, they are not being followed, and there is a lot of gap in implementation. So, since we have a gathering of lawyers from different states, what is your advice for better implementation of Supreme Court orders across the country? If you have any suggestions?
It's a very okay. So let me put the question in a little bit of perspective, and I'll just take 2 more minutes to.
Yes, sir.
Yeah.
Yes, sir. My name is C.M. Bhardwaj. I am from DLSA Northeast.
Sorry, I can't see you.
Yeah.
Okay, yeah. Sorry, yeah. Sorry, please say, sir. Please say. Sorry, I didn't see you. Yes.
Yeah, I said my name is C.M. Bhardwaj. I am from DLSA Northeast Delhi.
Okay, sir.
My simple question is, if the bail application has been dismissed by the concerned court, can it be filed with the under trial review committee for consideration? Without submitting second bail application to the same court?
Any question on UTRC? No. I'll address these similar questions. I'll address them and come back to you. So in 3 minutes, I'll quickly try to address this. See, what was happening was that there were, so I'll put it for perspective of everybody, Ritu. You must understand how, what is exactly an under trial review committee. There's more of it tomorrow. Supreme Court was faced with a situation where everybody was telling them there's a large number of under trials in jails, right? 67% to be precise, or 65%. The Supreme Court said, okay, why don't we have an independent mechanism of seeing if some of these under trials are in custody where they should not be in under trial custody. Now, how do you devise a system? So they took the MHA advisory and said, okay, we'll put an extra legal, it is not within any of the laws that there will be an under trial review committee, an extra legal body headed by the district judge, who is the topmost person as far as the district is concerned. He will review the cases on 10 parameters of every under trial every 3 months. A committee will review the cases and see if a person meets any of the 10 parameters. It will recommend to the concerned court saying that, sir, this person should ideally be granted bail or should be released on bail. I mean, going by a very limited definition. Unfortunately, this under trial review committee does not have any binding direction. It is not a court. Ultimately, the person who is in custody or by a judicial order passed by a judicial magistrate who may be a novice, who may be day one of judicial order. He may be putting somebody in jail. After 2 months, UTRC, who is headed by the senior most officer of the district, is recommending you release him. And the magistrate may say, sorry, I do not want to release him. These are the reasons. You can challenge the order, get bail from a higher court, but I do not want to release him. So these are all dynamics which is bound to happen. It was not contemplated as an appellate body. It is a review mechanism which has helped and will help a large number of under trials if it functions properly. And that's where the thing was there. We have realized, as the micros of the court, I am getting material from Sugandha, from Ritu, from Ajay, that, and I have also participated in UTRC meetings in Ghaziabad, Faridabad, Delhi, etc. There is a problem in working of these under trial review committees. Supreme Court has taken cognizance of that. Yes, there are needs to work on it. As lawyers, you can really help under trial review committees. In what manner? And that's very, very critical. Is please see those 11 parameters laid down by Supreme Court. In your legal aid experience, in your working experience, if you come across people who are covered by those 11 parameters, please bring it to the notice of your secretary DLSA. The secretary of the District Legal Services Authority is duty bound to actually bring it before the UTRC, and the UTRC is again duty bound to recommend to the concerned court to take appropriate action. It's a different matter that the court may say, no, you may be right in recommending, but I ultimately have the last word. So as Ritu said, we have a great role. If you are working as a legal aid lawyer, if you come across people in jails who are under trials, who are covered by the 11 directives of the Supreme Court for UTRC and they are still in jail, please bring it to the notice of the Secretary DLSA. He will probably be aware of it, but if you bring it to the notice, he will be able to do something about it. Most of the time, I guess. Okay, so I am sorry. Yeah, sure.
Sir, since you are talking about this UTRC committee, it is headed by the district judge.
Yeah.
So, don't you think it will be better if the district judge suggests something that it should be a mandatory on the magistrate, and don't you think it will help to reduce the overcrowding in the jail and will also help in trial. And except bail, only considering the bail aspect, if the review committee could also see the aspect of the case. Since they are also check, they will also check the FIR and the charges.
Yes.
Can they also recommend it to discharge the case if there is nothing?
Okay.
Because there is a provision as well.
Can the case go to the RC even after the rejection of bail order by the effects of higher courts and higher courts?
Okay, so going back, under trial review committees are based on data. Okay, when a meeting takes place, and I have participated in 6 of such meetings in the last 4 months, they do not have the case record. Right? They can't call for a case record because they are not a court. They are not trying. They are only saying this person. Okay, let me take an example. This person is entitled to be considered for bail because he has undergone half the sentence under 436A and he should be normally released. Or second example, he has been given bail but he is not being released because he is not able to furnish a surety of 50,000 rupees. Which are real cases I am telling you from my experience of taking part in these meetings. What does a UTRC do? UTRC says, oh, he is inside for half the sentence. Why is he not getting bail? You please recommend to the concerned court to take up his case immediately and pass an appropriate order in relation to his case. Now, UTRC can't give him bail. UTRC is not a court. It has no judicial functions. It does not hear the accused or the prosecutor. It doesn't know what is the background of the case. It doesn't know what is the criminal history of the accused. Maybe knowing, may not be knowing. We're trying to factor it in. It may ultimately go to the additional session judge or even the district judge himself on the judicial side, and he may say this guy is the most heinous of the offenders. He has killed witnesses after being released in a previous case, and therefore, even though he is entitled to a 436A benefit in this case, I am not going to release him unpaid. So that can play with him on the judicial side while sitting in UTRC as a session judge. Objectively speaking, that person has undergone half the sentence. But this UTRC has really helped people who have granted bail. That is again from the South Delhi district meeting which I went to. Somebody was a bail for 50,000 rupees. Legal aid panel lawyer. His job is done, right? Person comes, he is granted bail. The legal aid lawyer will say, person granted bail 50,000 surety. The job of the judge is done because he has passed a bail order. Actually, whether the person is able to give 50,000 or not, that has not been inquired into. Whether that person is actually given the surety or not, nobody looked into it. So that's what Ajay took it up. That was exactly the job UTRC was supposed to do for other, because Delhi will not bind other states. So UTRC in such cases should take up such cases, and that's what we are telling people. I am going out to districts and meeting session judges and telling them that you should take up such cases where there is a young offender. So up to 18 is covered by juvenile justice. As if suddenly in the midnight of 18, he becomes a mature person. So we said, please take up cases of 19 to 21 years, take up small offences, take up petty offences, compoundable offences. Please consider them. Please see if you can recommend release them on bail. So for UTRC, a recommendation goes to the court. It will obviously weigh in the mind of the judge that there is a recommendation to release him. If he doesn't do it, it's his prerogative. He cannot question it. So therefore, this is something which it's something like a review mechanism. It is nothing which can be legally enforced, but our attempt should be over 5, 10 or 12, 15 years that this institution remains and it is able to review cases on regular basis, monthly basis, 15-day basis, so that people are not in jail even for a day longer than required. Okay, Colin, I think my time is up. Okay, so I'll just take last 2 questions. So sorry, you had a question. I'm sorry. Okay. Last one.
But I think long.
Yeah.
The majority of the lawyers here are also representing legal systems.
Yeah.
And some of them might be appearing as an amicus.
Yeah, that's right.
And there is no uniformity. As Delhi has a good base structure. And I wanted to discuss with you, perhaps, if you think appropriate that their pay schedule of the legal and lawyer, because in Rajasthan, Jodhpur, I saw once in a week the jail visit is there 500 rupees.
500 rupees.
So the pay structure to legal and lawyer, and I'm talking as I'm also a legal and lawyer.
All of us are.
So in terms of the structure of hikers, in trial court, those were appointed. There is also pay structure by the court, and then the Delhi government or the state government pays it. Can there be a similar PI direction we can apply for application? Because for recruitment of prison staff, there is a PI direction that's come. So because this is a state subject, is it possible that we can request the court to pass appropriate direction? Because I think many of the states really underpaid legal advice.
In fact, I'm very happy to ask him, Colin, through HRLN, that you had put an application now, which is still.
Yeah, that's a forum. That's the national forum.
That the legal aid system being followed in Delhi should be replicated in entire country, because the Delhi legal aid system has had tremendous advantages, including good pay, great lawyers who are able to. I think so. That is something which I think Colin and I should be able to take it up in the next 5 months. Something which good you pointed at me. I had forgotten about this application completely. So thank you so much. I'm sorry I'm out of time, and I'm sorry I would not be available. I'll have to go back home. So meet you sometime. And in case you have any queries or any questions, just Google me up, write to me. There's no problems at all. And do look up these orders on PI. Thank you so much. Bye.